In fact, this is what they're not following. Had they been following this? Because this existing resolution itself has certain issues. It has a complete timetable. May I take your lordship to the 4th page of that document? 4th page.
Yes.
Your lordships, there is that bottom, the NOC is valid only for 1 academic year. So that's also an issue. Every year you have so many institutions, and every year if you go through these renewal NOC procedures, it's going to delay the matter. So the NOCs can be granted at least for 3 years. Because then you have new institutions also which are coming up. The thing is, they get money each year. That's the whole issue. And your lordship, there's a detailed timetable at the starts from the last 2nd page, both for new and renewals.
Page?
The last 2nd page of that same very document. They don't follow this, your lordships. They don't come up. If this is seen, say for 2023-24, the process should start in the year 22. The timetable, so there should be an advertisement by July. And this advertisement is not compulsory, it has to come up every year. So that means there's a subjective and objective view they have to take and come up with the advertisement. Then your lordships will see by 16th.
No, they may not come
Yes.
up with advertisement.
Yes, your lordships. So that means you'll have to do it on basis of facts and figures. So I have a doubt that they really do it. And then there is, they don't stick to this timetable. And then they have loads of application, both for renewal as well as for the new ones. And they can't. And this, again, this timetable, if it's seen carefully, actually matches the INC guideline. So that everybody is ready by March of every year, whoever has to participate. So suppose this year, so every year by March 2024, everybody is ready who are supposed to take students. And then we obviously by INC guideline says that by June of the year, you should have the entrance exam. But what happens is they don't adhere to this guideline, and they would be granting NOCs or withholding it without any reasons up to the end of the year. So that's one thing, one mistake which they are doing. That's what happening.
Where is that? INC guidelines.
Lordships. The INC, your lordships, guidelines they have attached in the INC has attached one. And INC, of course, again comes up with its own deadline every year. Like this, the year that we are talking about, they have come up under Annexure 5, page 51 of the second sub-item, your lordships. But INC literally does not have any control on these NOC grant or affiliation procedure. The second sub-item. (39868), Annexure 5, page 51.
You are referring to page 51.
51. Your lordships will see there is a timetable.
51 we are not getting.
Your lordships must be the second sub-item.
Second.
398.
All right. Just a Yes.
Your Lordships will see they had already notified that the entrance test to be conducted before 15 June 2023. Then the commencement of academic session was supposed to happen on 1st August 2023. Last date of admission was 30th September 2023. But in fact, they have extended till November. But till November, not a single movement happened from the DMAT side for this session. So even the existing admissions which have happened from the entrance exam also all have happened in the month of December. So that's one issue that we have in hand. I went through that judgment which INC is referring to. It was regarding one of these institutions which went to Delhi High Court saying that I want to take admissions. And then the court said, no, we are not going to extend. Otherwise, it's a never-ending process. And absolutely correct also. And then the matter went to Supreme Court, and Supreme Court thought also that, no, we should not disturb that position. It was for the year 2022, even if the COVID situation was prevailing. But the problem today we have in Odisha is an en masse problem. It's not confined to one institution seeking the problem. It's a problem which started because DMAT is not in sync. Neither is its procedures of NOC in sync with what INC wants us to do. Neither its own internal process of when to come out with the prospectus, when to conduct the examination is with the sync of INC. And if for so many years you did not, you allowed students to be taken, then this last moment notification also puts student to trouble because obviously we have students who are coming from outside the state also. And everything needs to be, even if there, but needs to be known and advertised accordingly. And simultaneously, new institutions were also coming up this year. So this is the mess we really have. So therefore, Your Lordships, for the students even who have taken admission, otherwise this becomes a 0 year literally.
This year, yes.
Yes.
We cannot do anything.
I do, but just this is all that I can really put forward, Your Lordships. And I can't quarrel with this position that, we can't keep coming to the court and saying that, I do understand that. And I'm very conscious of this. It actually is not good.
The order which we intend to pass is
Lordships.
that we will be asking the state government
Lordships.
to stick to their own timetable and with further direction that they shall not deviate in any case. And if they have to deviate, they will have to seek prior leave of this court.
Lordships.
Only this can, we think, solve the issue.
Lordships.
This year already.
Lordships. And already we have now
We are
700.
second of this.
yes.
We cannot violate the Supreme Court's decision.
Lordships. I am absolutely conscious,
Right.
and in fact, that was prevailing in my mind. I have been, in fact, telling even all the institutions
Right.
that, we are going to a place which will be a place of no return.
Right.
And this year, it is like it's a mess of a different altitude altogether.
So this is the order which we intend to pass in the present case. That you fix a timeline.
Yes, ma'am.
We give you liberty. You follow the time schedule prescribed by the INC, and in no case you shall be. And if you do that, you shall be liable to contempt of court.
Yes, ma'am.
So this is the order which we propose to pass in this.
And the issue of entrance exam should also be more publicly known, because for so many years, even the INC guideline was there since 2010. You yourself did not follow it, or whatever the situation was.
And this direction will not only be for this thing, entrance examination.
All the courses.
Right from the advertisement,
From the
inviting
entire academic
applications
session.
for NOC and everything,
Yes.
step by step.
Yes, ma'am.
You will have to either you do it or don't do it.
Yes, ma'am.
And why this NOC for 1 year?
NOC, because my lord,
Here.
INC has given their circular is there. Every year they will have the NOC. After 3 years, they will no more NOC will be given. No more NOC to
NOC
be,
will be required.
yes, they will give the appellation. Once the appellation is given, then there is no question of NOC
So where is that?
after 3 years. I have not, because my lord, I was not with those papers. Because this case is something else. That was not because there, I have placed it if my lord wants on Monday, all the documents.
The resolution shows that they have diverted from that. That resolution which I pointed out, last your lordships will see issue of final and renewal and recognition the council by council. But this is again is not being insisted upon. That's why your lordships, I raised that issue of reciprocity. Today, most of these private institution people who are coming out can only practice in state of Odisha.
My lord,
Only the government institutions and very good medical colleges where nursing is open, like in KIMS or Ashwini or some hospital, they have these INC recognitions. So that also needs to be taken care of.
So what is the, what, why?
my lord, we used to give NOC for the first time. Then we give renewal NOC for another 2 years. Then third year, we do not give any, we give them appellation, no more NOC is given. They are allowed to continue with the study. For first year, NOC, new, then new, renewal, then there is no NOC is needed. They get the affiliation from the university and board, and they continue with the studies.
Where is the requirement for grant of NOC? Do you have any idea?
Lordships, their own resolutions.
No, that is the resolution.
The Indian Nursing Council has got its
Like
regulations.
Indian-
my lord.
Some provision under.
Yes,
the-
yes, provision is there, my lord.
Your lordships, that's there, that annexure A/2 INC has given that.
Four 90. Page 490. 490.
This is only regarding the standards that any institution has to meet.
No, but where is the requirement of grant of NOC? Must be somewhere.
My lord, in my annexure, my counter, my lord.
See, going by the simple logic,
Yes,
one can understand that first NOC is required. So as to ensure that the institution or fulfills the basic, the required criteria.
yes.
All right. So that is the satisfaction of the competent authority
Yes.
that the criteria are fulfilled. Now, if there is a requirement of second NOC, then instead of the institution making an application for grant of NOC, the government or the authority may see if there is any deterioration or in any shortfall during this period, then they can decline. They can say they can in the first NOC they can merely say that yes, this is for 1 year only.
Yes.
And the second NOC shall be granted subject to fulfillment of the conditions.
Renewal.
You want some payment to be made, they will be making payment. That's all. But why this? Unless you reach a conclusion based on any inspection which you conduct, the state government, it's state government's function.
DMT.
Huh?
DMT, Director Medical.
DMT, yes. DMT is function. So if the DMT is of the view that further NOC should not be granted because of certain deficiencies arising after grant of NOC, All right. If the institution maintains that standard, when the first NOC was granted, then there is no reason why second NOC should not be granted. So that, are we clear?
Generally, my lord, past second renewal NOC.
If you
mostly
want money, you can take money.
for inspection, yes.
If you want money only for the purpose of for your revenue, you can take money from the institution, but or grant of, that should be a formality. Second, the grant of second NOC and third NOC should be a kind of formality only,
My lord,
unless you have reason not to issue that.
my lord, generally, renewal of NOC for second year, third year, we give. We go for inspection and get them immediately the renewal
NOC is granted by whom?
by DMT, by government on the recommendation of the DMT.
Why are you saying we? You are counsel.
Yes,
You are representing Mercy Council.
nursing, no, my lord. I am
DMT.
DMT, my lord.
Oh, you are representing
Yes,
DME.
yes,
Yes. So
yes.
second NOC you grant.
Only after inspection, if everything is there, we give them NOC, a renewal NOC. That is called renewal NOC. Third year also we give like that. There is no problem in giving renewal. Only the problem is there in giving a fast new NOC. The building and everything, we have to take care of that things. My lord, as my lord was trying to know, my counter, page 491, my lord, the notification of the Indian Nursing Council, my lord, page 494, guidelines regarding minimum prerequisites for granting suitability for BSc Nursing College of Nursing. Who can do it, my lord? May I place it?
Yes.
The following organizations establishment are eligible to establish a BSc Nursing College of Nursing. A, central government, state government or local body. B, registered private or public trust. C, organization registered under Society Registration Act, including missionary organizations. D, companies incorporated under Section 8 of the Companies Act. Then, my lord, the eligible organizations establishment should have their own 100-bed parent hospital, my lord. The conditions have already placed. May I place all these things, my lord?
Yes.
Total area, scheduled notified areas as the President of India may, by order, declare to be scheduled area. B, hilly area. UTs of Jammu and Kashmir and Ladakh, northeastern state, Himachal Pradesh and Uttarakhand. 3, the eligible organization establishment should obtain essentiality certificate, objection certificate from the concerned state government where the BSc Nursing College of the Nursing sought to be established. The particular of the name of the college nursing institution along with the name of the trust society company as mentioned in the trust deed or memorandum of association as also full address shall be maintained in the objective certificate, essential certificate. Then, my lord, next page. 4, after receipt of the essential certificate, no objection certificate, the eligible institution shall get recognition from the concerned SNRC, State Nursing Registration Council, my lord. BSc Nursing program for the particular academic year, which is a mandatory requirement. 5, my lord. The council shall, after receipt of the above documents, proposal by online, would then conduct statutory inspection of the recognized training in nursing institutions under Section 13 of the Act in order to assess the suitability with regard to availability of teaching faculties, clinical and infrastructural facilities, conformity with the regulations framed under the provisions of this Act. My lord. Then we have given everything. What are the essential? This is for BSc nursing, my lord. In all courses of nursing, they have given that separate regulations.
So where is the requirement of this NOC to be granted for 3 years?
No, my lord, it's not given here.
Then why are you doing that? Multiplying your own burden. And if any institution is found to be deficient,
Yes, ma'am.
you can take a decision. The
Proceed against-
decision
Yes,
will be
ma'am.
cancelled.
Nowadays onwards, we will, as per my lord's direction, we will do it. No further this thing. If there is some change or some differences there, then we will not allow them to be. Otherwise, we will allow them to continue and accordingly we will take steps for affiliation.
No, but where is the provision for permanent affiliation or recognition? You call it affiliation or recognition? What do you call?
Affiliation is from the board, that
Affiliation,
examination body.
right?
Recognition is from the council. Odisha Nurses Midwives Registration Council.
So once the recognition is by the nursing
Yes,
council.
yes, my lord.
So once the recognition is granted, it is obligatory for the university or the examining
To give affiliation.
to give
Yes,
affiliation.
ma'am.
That is mandatory
Yes,
requirement.
ma'am. Yes, ma'am.
So therefore, a recognized institution cannot be denied affiliation.
Yes,
All right.
that is there.
So, but if the recognition is granted for that particular academic year, then what about subsequent years?
We generally give provisional recognition.
Where is that?
That state government has some regulations. I will get it, my lord.
This is the regulation that they have. There's a copy of the kind of NOC they are giving. Your lordships will find annexure 2, page 24. This is what they give us first.
Provisional recognition.
They give us a provisional recognition. And now from this new university which has come up,
So this NOC is granted by whom? We are again confused.
yes, by
state
DMAT makes all the inspection.
So plus, please see this letter.
Yes. This body is also under the DMAT.
This
This Odisha
ONMRC.
Nursing, yes, Odisha
Odisha
Nursing and Midwives Registration Council, Director of Medical Education and Training. This Director of Medical Education Training not only looks after the MBBS or even the BDS, it looks after pharmacy, it looks after all paramedical courses also.
No, but this council must be a statutory body.
Yes, but it's the de facto is they work it. Same people, same. So they're like overburdened.
My lord, for the Odisha Nurses Midwives Registration Council, we have got a separate body with a registrar and other staffs also. This is under DMAT's office. And the board also is there, Odisha Nurses Midwives Examination Board.
No, then again, let us understand.
Yes, ma'am.
Who is required to grant NOC?
My lord, NOC is given by the state government on the recommendation by the council after inspection. And everything is done. They recommend, they write to the state government for giving NOC. On the recommendation of the Director of Medical Education Training, who is the chairman of the council also, the NOC is given by the government.
NOC is at Annexure 1, page 19. That's written there. Annexure 1, page 19. First paragraph. In pursuance of government approval obtained in so and so file, and cited above, I am to state that the following private nursing institutions have been granted NOC for opening so many courses with the annual intake capacity as indicated against each academic sessions 2023-24. So they do the inspection, send the report to the government. If the government says yes, then they issue this.
So what is the difference between NOC and recognition?
Once the institution fulfilled all the criteria, what essential for establishment of the institution, my lord, we give the NOC. After getting the NOC, again it
So
is.
annexure 2 is what? Whether it is NOC or recognition?
Annex to
It is a no objection certificate for opening of the institution.
Annexed to provisional recognition.
it's a recognition.
It's a provisional recognition.
Yes, ma'am.
The conditions are same, your lordships. If it looks at the conditions are
Unless there is a provisional recognition or recognition, the students cannot be admitted, and that is there.
And where is the provision for provisional recognition? Where is that?
that they have come up in this notification. This notification says that. But
They
not
must have exercised some power while
Yeah.
issuing that notice.
it says just a general guideline. And this is not only for nursing, this is for B Pharma, this is for M Pharma, this is for DMLT, physiotherapy, occupational therapy, all different allied
Okay,
medical.
nursing council.
My lord, the notification what Honorable Senior has already placed, my lord, that is of 21/2019, my lord. There is in the page NOC valid for academic year only. That is mentioned, everything is written there.
So the NOC is valid for 1 year. What about recognition?
Yes,
You are
recognition.
granting recognition
Yes, ma'am.
and in provisional recognition. And in that order, you are saying that the NOC is valid for 1 year,
Yes,
not the recognition. You can take a plea that recognition is valid only till the NOC is valid.
yes, ma'am.
All right. Therefore, the term of recognition shall also expire once the term of NOC expires.
Yes, ma'am.
This is your,
Yes, ma'am. Yes.
but you could have mentioned here that this recognition, provisional recognition is only for 1 academic year. And then where is the provision for grant of provisional? There must be some provision in the INC.
My
Yes,
lord,
page 15 of the counter affidavit filed by my learned senior in 39868. There, column number 4, after receipt of the essentiality
Page-
certificate,
Page.
page 15
Oh.
of the counter affidavit filed by DMET. madam. There, column number 4, after receipt of the essentiality certificate, no objection certificate, the eligible institution shall get recognition from the concerned SNRC.
Where is that?
Running page 495.
page 15, my lord.
495.
Running page.
495.
Yes.
Top of the, after receipt of the essentiality certificate, no objection certificate, the eligible institution shall get recognition from the concerned SNRC for the BSc nursing program for the particular academic year, which is a mandatory requirement.
That is what I placed, my lord. That is State Nursing and Nursing Registration Council.
And what is the name of the act?
That is the notification
What is
issued
the
by the
name of
Indian
the act?
Nursing Council.
Indian Nursing Council,
That the notification,
my lord, page 491, the notification I have given in my counter, 491. That is there. Indian Nursing Council's revised regulations and current
What
Correct.
is the name of the act?
Indian Nursing Council Act.
Indian Nursing Council Act 1947.
First line. First line, page 491. First line. In exercise of powers conferred.
section 1 of
Section
section
one of
16 only.
Yeah, no. Chief, Odisha, लेकिन Odisha Nursing Council, SNRC with actually. लिखा है कि Odisha Nurses and Midwives Registration Council MCR का के rules थे. This act of Odisha Act is still in vogue or is over?
No, that is
Repeat.
there.
Yes,
Yes,
it is prior to this
47. Prior to INC also, my lord, we had for that.
this is
Odisha.
1938.
Yes, ma'am.
यहाँ पर अगर rules also है.
Which is that regulation? Because regulation. Whether they are regulations framed under section 16.
16. Your Lordships, in that regulation, they have stated so. In exercise of its powers conferred under subsection 1 of section 16 of Indian Nursing Council, 1947, as amended from time to time, the Indian Nursing Council hereby makes the following regulations. See, regulations under that section 16 of the Act. That same running page 491. It says so.
And whether the state government has also such power to make regulations under the act.
There is act, we have one state act also.
Is there any amendment after the that this 1938 Act, State Act is. Right.
It's still there, my lord. We have not amended to it. No
No.
amendment has been made to the act.
Your Lordships, the
Effect of subsequent enactment.
yes, that would
By the Indian Nursing Council.
Huh?
By the Indian Nursing Council particularly. So we are following the Indian Nursing Council's these regulations, what they're giving.
Why are you following? This is your act, then you don't follow.
This higher education, I think, falls under the concurrent list. But the this 1947 Act does not give the State Council any power.
Therefore, we want to know.
Yes, so it does not.
Because he has referred to this 1938 Act. 1938 Act. Whether it survives or not.
We have not yet repealed that act. That is still
No,
there.
you
because
might
it has
not have.
not-
You might not have repealed, but
But then it gets.
in terms of 1947
Yes, my lord.
Central Act, if it is,
This will have no effect. That after the 1947 Central Act, being the concurrence list, so naturally we have to follow the INC guidelines.
Right.
because state, whatever is there,
But also the power you have.
Yes, madam. Yes,
Nurses and midwives, registration rules की कौन सी बात है? देखो,
But please provide us all the law.
yes, madam.
Like we add regulation.
Under this act, Odisha Act,
Yes, madam.
there must be some regulation or rules, because rule making power is given to the much prior to 1947.
Your Lordship, give us a minute.
Supreme Court says that all the admissions
Yes, my lord.
allowed after that age,
Yes, my lord.
cutoff age,
Yes, my lord.
are illegal.
Yes.
This is what we have done.
Because, my lord, as I was,
And the degrees obtained, the Supreme Court says, we may have no resolution.
admission should have been as per the court of,
Cure.
yes, my lord.
I don't know how are you going to compensate those who have been given admission.
Admission, they have not taken, my lord, because only very few have taken admission as per our list.
They have not been given admission and only few have been given
Yes,
admission.
my lord.
There is a huge gap between these two statements.
Because from the merit list, still to 10,000
Maybe it's a
some.
question of merit list. Third person. The order is reserved. Okay. So it is clear that this is we shall be issuing certain directions
Yes.
to be strictly followed in future.
Yes, my
For the present, we are helpless.
And just for the benefit of the students, I think they have already taken admissions. After December, according to the statistics they have produced, 700 are there today in the
We
government.
cannot do, we
Yes.
don't
So I
want to
think-
comment.
Yes, that's
That
what.
any comment on their admissions shall be to their serious
Yes.
detriment.
Yes.
And
Therefore, we shall just be avoiding that part. Let
that's,
us see what happens.
yes.
Thank you. Hmm? Do you have received any instruction?
No, so far the instruction is concerned, as per our instruction, after cut-off date, no admission shall be allowed.
Then how will you protect what
That,
has happened?
that is the lookout of the DMD. In spite of our specific direction, in
You
spite of the
represent whom?
Indian Nursing Council, madam. We have fixed the cut-off date on 30/11/2023. In spite of that, they are taking admission.
So what will you do?
That we have to receive instruction whether any action will taken against those institutions.
They also so moto extended it to November. I hope they had also stuck to the stand. And
No, no.
stuck to the stand of, And I think the Act also says that whenever a state wants a new post to come up, they do take confirmation from the council, that means the central council. And they do have powers to do the inspection. So kind of they've also, like, unlike the courses under MBBS, I mean, the medical council there is very active. The dental council is very active. Somehow the nursing council should be active.
Item number 2. Yes.
Yes.
Item number 2.
No one appears on behalf of the petitioner. This application is dismissed for default.
Item number 3.
May I please, Your
No
Lordship?
profit.
May I please, Your Lordship? On the other day, Your Lordship, I was submitting that the final order of the revisional authority, I have checked up, that was passed under section 15B of the Survey and Settlement Act. After publication of the ROR under section 12B. And the Honorable High Court, Honorable Single Judge has held that the revisional authority cannot decide the disputed question of fact. But the fact remains that all the disputed question, all the dispute arising in the lease was to be decided by the revisional authority under section 15. So therefore, my lord,
So that order is under Article 227.
my lord,
That order is, order of learned single judge is under Article 227,
226,
226.
226. Your Lordship, may order is at page 77. Annexure 11. For the disputed question of facts involved, there was no scope for the authority under section 15B of the OSS and Act 1958 to adjudicate such dispute.
So disputed questions of fact cannot be gone into that.
No, my lord, so
At
far
this
as the
stage of revision.
revisional authority, my lord, the fact remains, my lord, the petitioner purchased the land, but it was not recorded in his name, whereas from the same vendor, another person purchased.
So you could have filed a
Yes.
suit.
Yes.
This is
No, my
what the
lord.
court says.
There is a
No,
rival
my lord.
claim. There is a
So far
rival-
as the my lord, suit is concerned, suit can be filed only within 1 year from the date of final publication. And your lordship, section 5 of the Limitation Act is also not applicable, my lord.
So therefore,
Therefore, my lord, the revisional court, while
because you did not file a suit, therefore the revisional court will have to decide what the.
no, not on that aspect, my
Yes.
lord. Since the ROR was published under section 12B of the Survey and Settlement Act, the revisional authority has
So
the
therefore
power.
ROR determines the title.
No, my lord.
That-
It neither extinguishes nor creates title, but so
Right.
far as the entries in the ROR is
True,
concerned,
true.
when it is wrong, it has to be.
You are very clear on every aspect of law,
No, my
you
lord.
are still pressing.
My lord, the fact remains, my lord.
It's
my
not
lord,
that you,
The
Mr.
observation
Counsel,
of the.
we understand that you
My
also.
learned brother, my lord, also agree with me that when there is a disputed question of fact, it has to be decided by the revisional authority, my lord. The law is well settled, my lord. The revisional authority is
All right,
cannot.
let us see the provision again.
You have to distinguish between revision and appeal. Appeal can reappreciate the evidence and factual aspects, but
My lord,
revision-
there also, my lord, in the revision application, he has challenged the order of the appellate court, my lord,
that is what.
and he has. Your lordship will find the order at annexure 10, my lord, of the revisional authority, where the appellate authority has rejected his appeal.
So when was the date, what is the date of final publication under section 12B?
My lord, the date of final publication was 2/5/2017, and the rate was fixed on 1/4/2018.
Then you could have gone to invoked section 42.
Since, my lord, appeal, I preferred appeal, and the appeal under annexure 8, the order of the appellate court is there, my lord, passed by the sub collector, rejecting my appeal. Therefore, I preferred the revision challenging the order of the.
No, you could have preferred the reason only if you could have taken such points available for a revision.
Yes, my
So
lord.
in case of dispute, you could have invoked section 42. which you
My
did
lord,
not do.
so far as the disputed, the revisional court has not rejected my application on the ground that it is a disputed question of fact. I cannot decide the revision.
Then
He has decided on merit, my lord. So therefore, the observation of the honorable single judge is contrary to the decision of the revisional court. Revisional court has never said that it is a disputed question of fact. I will not entertain the revision, or I dismiss the revision. Revisional court, my lord, decided on merit. So therefore, the honorable single judge has committed. The order is error, my lord, to that aspect, my lord.
So in your case,
My lord.
the ROR was published on
My lord, on 2/5/2017, my lord.
2/5/2017.
My lord. And the rent was fixed and finally published on 1/4/2018. My lord, the commissioner has also observed, my lord, I have filed it in there was some delay and the delay was taken care of.
So where is the provision for revision against appellate order?
My lord, there is no such provision.
Then
My lord, so far as the revision is concerned, my lord, the revisional court has decided the
Mr. We are putting a
Well,
question.
there is no such provision, my
Then-
lord. 15B, there is no such provision. The provision is available under section 25, my lord.
25.
25, my lord, to challenge the appellate order in revision. But that is prior to 12B, publication of the ROR under section 12B.
So therefore,
My lord, what has happened in between passing of the appellate order and preferring revision under section 25, the final ROR was published. Therefore, the petitioner filed the revision under section 15B, my lord,
against ROR,
against the ROR, my lord.
not against the appellate order.
Not against the appellate, but the appellate authority, the revisional authority decided the question which was decided by the appellate authority and rejected the revision.
So according to you,
My-
the revisional authority did not have any jurisdiction to decide the order passed or to consider the or to set aside an order passed by the appellate
Appellate
authority.
authority, my lord. Up in 15B, in under section 15B.
Let us see what is there in section 25.
My lord, 25, my lord, any appeal filed under section 22B,
25.
my lord, 25, my lord. Revision by the
So
Board of
your
Revenue.
appeal was filed against which order?
My lord, my appeal was filed against the order passed by the Assistant Settlement Officer under section 21(2). Section 21(2), after preliminary publication of the ROR.
Section 21,
Section 21(2).
you had filed appeal.
No, my lord, filed the objection before the settlement Assistant Settlement Officer. Against that order, I have preferred appeal under section 22(2) of the before the settlement officer, my lord. I'm reading out the section
Please,
22.
please.
Sorry.
Section 22 is not an appeal.
My lord, 22B, my lord.
This is not an appeal.
My lord, on application 30 days from the order passed on an objection preferred under section 20, subsection 1 of section 21. I have filed objection under section 21, 1, my lord. Preliminary, against the preliminary publication, my lord.
So you did not prefer any appeal.
My lord, I have filed the application That is called.
Why are you saying this appeal?
They have
Where is
nomenclature.
the question? You may be calling something an appeal.
No, my lord, the authority called it as an appeal, my lord.
Sir, you are a counsel.
My
You
lord.
are required to tell us
Yes, my
the
lord.
nature of application which was filed by you.
I
So
have
this
filed,
22 is not an appeal.
that is the application, my lord.
Yes.
22B, my lord. The application was filed against the order passed by the assistant settlement officer.
Yes.
So thereafter, my lord, if it is rejected, then 25 is the provision for revision, my lord.
So revision against which order?
Against the order passed by the authority under section 22B, my lord.
22B.
My lord.
So read section 25.
My lord, section 25B, my lord, your lordship may kindly read.
Yes.
Kindly see. On application made within 1 year from the said order, my lord. Direct revision.
Which order?
My lord, the order passed under section, my lord, 22B, my lord.
How do you read that?
By the revision by the Board of Revenue, the Board of Revenue may, in any case, A, of its own motion or any time date of final publication under section 23, my lord, or on application made within 1 year from the date, said date, with direct revision of the rent so settled, but
So this is regarding settlement of rent only.
my lord.
So how do you relate this 25B to an order passed under section 22?
My lord, therefore, my lord, since final publication was made under section 12B, the petitioner filed a revision under section 15B, my lord. There was no scope for him to agitate the that order under section 22B order before any authority. Therefore, he has filed the application under section 15B of the Survey and Settlement Act, since the final publication was made under section 12B, my lord.
So Mr. 15B is for a very limited purpose.
My lord.
When the records of rights are
It's
published,
finally published.
then either on its own motion
or an
or
application.
an application.
My lord.
So that
I
is
have
the
made the
power.
application.
So you made an application.
My lord.
So whatever order has been passed,
Right.
that is different.
My
The
lord.
question is of your right and
My lord.
title. You could have invoked section 42.
My lord, so far as my right is concerned, I have filed agitated my right under section 15B. Under section 15B.
Yes.
To correct the ROR because of these are the documents on the basis of which
So the 15B has its own limitations.
Yes, my lord. But the revisional authority,
Yes.
while adjudicating the revision, has relied upon the order passed by the authority below under section 21 and 22B and rejected my appeal.
All right.
So thereafter, I rejected my revision. So therefore, I prefer the writ
We do not
application.
find any illegality in the order. Yeah.
My lord, may I pray, my lord, one thing, my lord.
Yes.
If your lordship, my lord, the revisional authority says that I could not produce the document. So if your lordship will relegate the matter to the revisional authority,
No.
I will produce the document and thereafter
No,
you
this
will.
we will not do. If you can take recourse to section 42, it's all right. Otherwise, very difficult.
My lord, but so far as my lord, section 42 is concerned, it is, my lord, the barred by limitation, my lord.
Maybe.
So that, my lord, so far as the suits are concerned, my lord, civil suits,
So you want to overcome that bar.
my lord, because I have proceeded under section 15B, therefore, my lord, my right has been affected by the order of the Honorable Single Judge, my lord.
Sorry. This is 44, 25B, why are you referring to this section?
No, my lord, that is
A wise counsel like you,
my lord,
how can you refer to this provision within 1 year?
my lord, 25 is always prior to my lord publication, final publication, my lord.
Yes, 25, that 1 year is, there are two circumstances
My lord,
when the power under section 25 can be exercised.
yes, ma'am.
Either on his own motion,
Or on
no limitation,
my lord,
no limitation.
no limitation.
Or an application filed within
1 year.
1 year.
One.
That is the limitation.
Yes, ma'am.
So for A, there is no limitation, for B, there is
1 year.
limitation.
But
Then,
that power can be exercised only prior to final publication of the ROR.
yes.
But 15B is the provision where after final publication of the ROR. So that is the difference between, my lord, provision of 25 and 15, my lord.
After having.
So, my
gone
lord,
through- Sorry.
what I trying to impress upon your lordship, my lord, the honorable single judge, while adjudicating the writ application, my lord, observed that the revisional court cannot adjudicate the disputed question of fact. But in my case, my lord, the revisional authority has not rejected my revision on such ground, my lord. Therefore, my lord, the honorable single judge should have decided the matter on merit, my lord. So I pray, my lord, let it be either remanded to the honorable single judge for fresh adjudication for taking a view, or to the revisional authority, my lord.
The appellant had put to challenge in a writ proceeding before this court an order passed by the revisional authority dated
My lord, revisional authority dated, my lord, 4/8/2020, my lord.
4/8/2020 passed on an application made by the appellant under section 15(b) of the Odisha Survey and Settlement Act 1958. So stop. From the pleadings on record, it is evident that the case involves disputed questions of fact regarding title. Title is not involved.
My lord, title involved, my lord, the record was in the name of my vendor.
No, the petitioner, the appellant, had questioned the correctness of the entries made in the records of right. So stop. The said application, the petitioner's revision application, assailing the entry under section 12 capital B, was rejected by the revisional authority. Stop. The learned single judge has dismissed the writ petition on the ground that as the case involved disputed question of facts, comma, the revisional authority ought not to have, could not have adjudicated upon such dispute, exercising his power of revision under section 15 bracketed B of the said act. Stop. Accordingly, while dismissing the writ petition on 28/12/2022,
My lord,
the,
11, 22/11,
28/11/2022,
28/11.
28/11/2022, learned single judge gave the petitioner liberty to invoke appropriate remedy available to him. So stop. Next. Section 42 of the Act. उसको कर. The petitioner, the appellant, has questioned the said order said order passed by the learned single judge in the present intra-court appeal mainly on two grounds. So stop. Learned counsel for the petitioner has submitted that learned single judge has committed an error of law while holding that the revisional authority did not have the jurisdiction, did not have the scope to adjudicate upon the disputed questions of facts. First off, he contends that the revisional authority does have such jurisdiction. First off, he has secondly submitted that the learned single judge committed an error of record while passing the order without taking into account the fact that the revisional authority had not dismissed the petitioner's appellant's application for revision on the ground of lack of jurisdiction. Rather, it had dismissed the revision petition on the ground that the petitioner could not bring on record certain documents essential for determination of his rights. These are submission.
Yes.
Next. We are, after having gone through the records of the case, we are convinced that the questions which the appellant raised before the revisional authority and this court, while assailing the order of the revisional authority, involved disputed questions, such disputed questions of facts with relating to title based on the title of the petitioner's vendor that could not have been adjudicated upon in a proceeding under section 15 bracketed B of the Act or under Article 226 of the Constitution of India. So stop. We accordingly do not find any merit in this appeal, which is accordingly dismissed. Which stands dismissed.
Item 4.
Yes.
So in item 4, question to my lord, may kindly see the order dated 31/24. I have filed the additional affidavit, but I couldn't get the respondent. So I will serve copy today if he appears.
Learned counsel appearing on behalf of learned additional government advocate states that an additional affidavit has been filed, but without serving a copy thereof on learned counsel for the petitioner,
Well, for the respondent,
no, for the counsel for the respondent,
respondent one.
respondent number one. So stop. Let it be done by Monday. Let a copy of the additional affidavit be served upon learned counsel for the respondent number one by Monday. So stop. Sole respondent by Monday. There is no representation on behalf of the respondent today. So stop. Place this case on 1 week.
Item number 5.
I beg to submit, my lord. WA number 3119 by 2023 connected common judgment, my lord. It should come, my lord, and 376 days delay, my lord.
So what do you want? You want us to dismiss your appeal on that ground?
No, my lord, no.
Huh?
Another WA petition is there, connected, common judgment was passed. Same issue, RS scheme.
So on the same ground, that appeal can also be dismissed.
No, both appeal I filed, my before. Both appeal should come here, my lordship. It may
For
come next.
dismissal.
It may come on Monday, my lord, with the, along with the WA number 390.
It is
Three
stated
one
by
one-
learned counsel for the appellate that the order passed by a learned single judge of this court, which is under challenge in the present appeal, is also under challenge in WA number
3119 by 2023.
31199 of 2023. This is matter on 1 week along with WA number so and so.
Item number 6.
Right, item number 6, also direction I filed by so cause lot.
Yes.
That has been filed not so.
Yes, it is there.
12th of November, I filed the so cause lot.
Yes, compared with.
No, complaint, it's a, their allegation is that there was an order of status quo in a pending application lots and that is being violated by the opposite parties. So contempt was filed, now the writ petition, so also the lots contempt are before lordships. I filed a so cause, detailed so cause affidavit, lots. My friend says he
I had not received any copy of the show.
I'm serving copy in course of the day, lots may call it some other day.
No, but is it a fact that you have violated the
No,
status
we
order?
have said that we have not violated. I've given a detail, lots, it's a government land, I've given the details, lots. I'll serve a copy on my friend, lots may call it some other day, so that can be taken.
If there is nothing in contempt, let the main matter be decided.
Yes, that I'm saying.
No, my lord, I pray only a passover because Mr. Senior Counsel is on some other court.
All right. So where is that writ petition?
It's connected, there along with this writ petition,
Connected
they're today in the list, before lots of vote.
as requested on behalf of the petitioner. List this matter on Monday. Let a copy of.
Let him serve the copy a week.
Yes, we are directing.
A week.
Let a copy of the so-called reply filed by the contemners be served upon learned counsel for the petitioner in course of the day.
Yes.
I pray maybe matter may be taken up on Wednesday, my lord.
1 week we have it Thursday.
1 week. Obliging.
I'm sorry, Bilal.
No, you don't. We'll just come back to them.
Yes.
All right.
In fact, not if the writ petition comes up for a final disposal, there'll be no need to take out the violation of the contempt matter.
This is what we contemplate.
Yes, Malad. The writ petition, the pleadings are complete.
All right. So we can do that.
Yes.
Item number 7.
But so far 7 is concerned, Milords, there is a direction for payment of 24 lakhs, Milords, and that amount has already been sanctioned and he has submitted his account number and the treasury has been directed to make payment. Either he will get today or tomorrow, within a day or two, he will receive the amount. I have given my sister the details of
It will
the
come tomorrow.
account number she has submitted.
It will come tomorrow.
So we call it day after tomorrow so that she can say whether because
Day after tomorrow may become,
oh sorry, Lord, I'm sorry. Day after tomorrow is already Monday. You also may call it. By that time it can be paid, Milos. No,
you'll have to do it.
no. Already, Milos, I've given the
As-
details of my.
As London Council, London AGA, representing the state of Odisha, has submitted that this court's order shall be complied with within 2 days.
Yes.
To stop, list this matter on Monday.
Item number 8.
When I've got the
Compliance
WhatsApp
is-
message details, I've said with my
Yes, yes.
friend.
Pay.
Yes.
Item 8.
Madam, may I please?
Yes.
My lord, this writ petition has been filed on the ground that the honorable single judge has failed to appreciate that the order violates the principles of Insurance Act. Number one,
Principles
number
of?
Insurance Act.
Yes.
My lord, as far the petitioner is concerned, I am the nominee of the insured. And the lower court, honorable single judge has passed an order to disburse the death death claim amount in favor of
Yes.
manner. As far as the statute is concerned, it is clearly says the death claim amount has to be disbursed in favor of the nominee. But as far as section 39 of Insurance Act, and may I please this one? Okay. The 39 says the holder of a policy of life insurance on his own life may, when effecting the policy or at any time before the policy matures for payment, nominate the person or persons to whom the money secured by the policy shall be paid in the event of his death. Accordingly, this is first one. And 39(6), this comes specifically that says where the nominee.
Section, which section?
My lord, 39, 639. At this 39(1). Then comes 39(6). What it mean, lord?
Yes.
That's it. Where the nominee, or if there are more nominees than one, a nominee or nominees survive the person whose life is insured, the amount secured by the policy shall be payable to such survivor or survivors. And the 7 says
Direction.
bigger part.
So they were not nominees.
No, I am the nominee. And the what is their what they say? His legal hire.
And who are you? How are you related?
I am the nominee of that. I am the father of the deceased. And when the deceased got into this insurance, he has nominated my name. I am the father of the nominee. And the
And
claim.
who are they?
Pardon?
Who are they? Who is your grandson?
No, my son has expired.
Those who claimed.
No, those who claim is the wife and the grandson.
Your
No.
grandson and your daughter-in-law.
daughter-in-law. My lord,
So you want that the amount should not be paid to them, rather it should be paid to you.
my lord. And with the condition, I don't claim the entire amount because I'm a person of 87 years old and another son is mentally retired. We don't have a single pie to survive here. And what has happened after the death of my son, my daughter-in-law left the place and I have annexed all the
That is
documents.
different. That
And after going this
it's a
way,
legal issue only. Pure and
my lord,
simple.
purely it's a legal issue.
You should notice. Someone is appearing for the other side.
No, I have issued to appear for the insured.
40?
4 and 5. I conducted the matter in the before the learned single judge. I have filed a counter affidavit stating that we can only, in the face of section 39, we can only play to the nominee, that is the Dibakar Sahu
To
appellate.
notice.
But it is 10 years old matter. It has been, he has taken almost all of his proceeds out of the insurance policies. Now the agency benefits under the agent's regulations.
Who
He
has
is to
taken
get
money?
Miller, the appellant, who was the opposite party in the writ petition, he has, because the death occurred of the life patient in 2010. And that, and having.
So the money has already been received by him.
No.
Almost everything. Only agency benefits like gratuity, some ex gratia, under the agent, he was an agent. That
No, there are two aspects.
Miller,
The insurance amount you may be entitled to receive
Minor.
as per the terms of the policy.
Minor.
But rest of the amount you
No,
cannot get.
I'm not claiming that also. I'm not claiming on that. I'm connected with only my insurance, where I'm a nominee.
my lord, the amended act that section 39 gives a beneficial interest to all the legal heirs,
Where is
including the nominee. Your lordship knows.
Where is that?
In section 39.
39.
But the learned single judge has, to the exclusion of the nominee, has directed to pay only to the wife and his son. Of
No,
the
you are
life
referring
assured.
to which 39 what?
39, 790 declared.
7 May I please? 39(7). What he said. Subject to the other provisions. 7. Subject to the other provisions of this section, where the holder of a policy of insurance on his own life nominates his parents, or his spouse, or his children, or his spouse and children, or any of them, the nominee or nominees shall be beneficially entitled to the amount payable by the insurer to him or them under the subsection 6, unless it is proved that the holder of the policy, having regard to the nature of his title to the policy, could not have conferred any such beneficial title on the nominee. Yes.
You are not the nominee. You are not the nominee.
I am the nominee. I am the
He is
father. I am
father was the
the
nominee. Before marriage, he was set as the nominee by the life assured.
And 7 says, if his parents are also coming, I'm a parent. I'm a father. And as far as the role of legal head is concerned, it has been mentioned in section 8.
Last paragraph, which I agreed upon. Data and total.
Now, what is paragraph 7 of the order?
Sir, the last.
Seven.
Learned counsel for the opposite party 1 to 3 further submits that the father-in-law of the petitioner number 1 is the nominee of the policy taken by DC
Who was
Chandrasekhar.
opposite party number 1?
Beg your pardon?
Who was opposite party number 1? To three?
Was it?
2, 3 for LIC was it?
Opposite party number one was the LIC.
I filed my counter stating the
1
law.
to 3.
And you were which opposite party?
I was the nominee. I was opposite party number 4.
4.
4. All right, make sure noted.
My lord, there is an IA filed by me.
Both processes.
The operation of that order may be stayed.
1 week. No, registered for
Annex your, किसका कोई
And-
annex होता है.
week for 1 week. Entry. Stop. Selling the impugned order passed by the learned single judge dated 1/2/2024 in WPC number 18802 of 2023. Learned counsel for the appellant has drawn the court's attention to the provision under section
39.
39 of the Insurance Act 1938
Next.
that the petitioner being father of the policy holder and nominee of the insurance policy could not be denied payment of a part of the insured amount in accordance with subsection 7 thereof.
7.
So stop. What is your share?
That will be 1/3.
1/3.
1/3.
Stop. Next, we are prima facie satisfied with the submission advanced on behalf of the appellant. So we accordingly direct that that 1/3 of the amount directed to be paid to the writ petitioner bracketed opposite party number who?
And the writ petition opposite party number 4. Appellant is the opposite party number
No,
4
no,
in the
here
writ petition.
their opposite party is number
4.
in the
Here.
writ appeal.
Here is the
Yeah. 1, 2, bro.
1, 2, here, 2 and 3. Sorry, 5.
3, 4, 5.
3, 4, 5. Opposite party.
Since I have
number-
appeared for them in the learned court below, before single judge, I will take notice. 3, 4, 5, and 5.
We accordingly direct that in compliance of the order passed by the learned single judge, the insurance company may release 2/3 of the amount on insured amount in favor of respondents number
1 and 2.
1 and 2.
1 and 2.
All right.
Let me
IN
record that
number.
I have insurance to appear for 3, 4, and 5.
All right.
Insurance company.
Learned counsel for the respondent number 3, 4, and 5 is present.
I have received a prior copy. I will take further copies for sending to all the parties.
Let copies of the writ appeal
Inter de debe.
be served upon.
Subrat Kumar Mohanty, advocate.
Huh?
Subrat Kumar Mohanty.
on Mr. Subroto Kumar Mohanty, learned counsel for
Realization.
opposite response number 3, 4, and 5.
Millard.
Stop. IA number so and so stands disposed of.
Millard.
Obliged. It should not have a state being there or.
Item 9.
I'm appearing for the opposite party number 1. My Vakalatnama I have filed yesterday. It is not there, my lord, lordship. Lordship, this petitioner has filed challenging the order passed by the real estate regulatory authority. As your lordship knows, this is a
You have received his Vakalatnama also.
Yes, my lord, I have filed Vakalat.
No, his Vakalatnama also you are carrying.
No, my lord, I am not. Yes,
Allow him.
my lord, let.
My lord, may I please? My lord, Annexer 3, under, my lord, under Annexer 2, I made application before the Real Estate Regulatory Authority for registration of the project, my lord. Under Annexer 3, the
No, but he has filed Vakalatnama, whether the Vakalatnama is on record.
No.
It is stated at the bar that a Vakalatnama has been filed on behalf of
Real estate regulatory authority, opposite party number 1.
a real state regulatory authority, bracketed RERA, comma, opposite party number 1, which is not there on record. List this matter on 1B.
may I, your lordship kindly allow me. My lord,
The-
yesterday I,
Just a minute,
My lord.
with the said Vakalatnama on record. Yes.
my lord, yesterday I received a notice from the regulatory authority that if I will not remove or deposit the amount which was directed to deposit by under Annexer 3, then my registration application will be cancelled by 4th of March, my lord. That is on Monday, my lord. And accordingly, yesterday also I filed a IA for interim order, my lord.
Because
Because
this writ application itself is not maintainable.
No, no,
I wanted to
I
bring to
will,
your
I will
lordship
argue on merit, my lord.
Yeah, IA has not, it's not on board.
My lord, that is in the file, my lord, what I have, because by 4th of March, my lord, your lordship kindly, this is the letter yesterday I received,
But you will have to establish a prima facie case.
my lord. Your lordship kindly see Annexer 3. Annexer 3, under Annexer 3, the authority pointed out a defect that I had to deposit a amount of rupees 3,82,000, which was directed to deposit to the promoter in another case, which was no way related to this project, my lord. This is a resident, this is a flat, in another plotted scheme. Law and authority directed me to deposit rupees 3,82,000,
So you have so many projects.
my lord,
In respect of one project, you are required to pay some amount.
my lord,
So that has been made a condition for
my lord, my lord.
in respect of the other project.
My lord. And the
Payment of
earlier
that
order
amount.
that is pending before this honorable court that has been challenged in WPC number 10681 of 2022. And in that case, this honorable court, division bench of this honorable court, pleased to issue notice to the authority and the private opposite party, my lord. Here, my lord, my case is in that earlier writ petition that I had deposited the amount or the honorable.
No, we are not hearing that writ petition.
My lord, here the urgency is by 4th of March. I have to,
We are not hearing that writ petition.
my lord. But that order is challenged before
That
this
writ
honorable
petition
court,
was taken up. In that writ petition, notices were issued,
my lord.
but no interim order was passed.
My lord,
That must have been declined.
no, my lord. In
Yes.
that case, my stand is The amount which was,
Forget, we are not hearing that case.
my lord, that is already deposited, my lord.
All right. Yes.
May I just
Yes,
bring to
just a minute. Yes.
Lordship's notice? Your Lordship's knows that under the Real Estate Regulation Development Authority Act, my lord, any order passed by the authority, my lord, is an appealable order. And while passing the order, my lord, the RERA authorities have written therein that CC case number so and so, you have not paid this much amount of money. If he is agreed by such an order, my lord, the appropriate course of action would be to invoke, my lord,
So when was the order passed?
43(5).
53, this is a this is passed in our,
All right. So do you admit that you had that remedy of filing appeal?
no, my lord, because this is an administrative order, my lord. This is no, on my, I made an application on online application. That is.
All right. So is there any bar that administrative orders cannot be challenged? If according to you, see, that order was passed. That order was passed by RERA. That order was passed under the Act, exercising some power under the Act. You could have challenged that in appeal.
Your lordship, kindly, Annexer 5, I will place only, my lord, Annexer, sorry, my lord, Section 5. The grant of registration. 5(1), on receipt of the application,
Mr.
my lord.
Come to your appellate provision. If you say that the appeal would not lie, then it's a different matter.
My lord, my humble submission is that this is passed on an administrative
The
side and that is
direction
deeming
for
provision.
deposit,
If,
direction for deposit was made in November 23. You challenged that in writ.
my lord,
Why you are
Writ
challenging, my lord,
application
because you
in,
have to pay the money
in
otherwise.
January 24.
my lord, that
we are
amount already
fi-
deposited, my lord. That amount which was directed by the authority, that is already collected by
Tell
the,
the appellate authority.
that is already
the order is
intimated, my
wrong.
lord. That has been collected by the Honorable Apex Court and that is available at the competent
Tell
authority.
the appellate authority that that order is in. The
My lord, that order is challenged before this Honorable Court.
all right. Oh, one item.
9.
Petitioner has put to challenge, comma, in the present writ application under Article 226 of the Constitution of India, comma, an order passed by the real estate. What is that?
Regulatory authority.
Regulatory authority dated 4/11/2023, whereby the petitioner has been asked to pay a sum of rupees 3,82,000 for 82,000, which was due towards registration of another project,
My lord.
namely High-Tech Plaza NX. First off, next London Council for the petitioner has not disputed that there is a provision for appeal under the Act of the
Real Estate Regulation Development Authority Act.
authority under section
Section 43, clause 5.
3 clause 5 of the so and so Act, which he has not availed. So stop. When did you file this petition?
This petition has been filed on 19th of January, ma'am.
Nearly 3 months after passing of the order by the RERA, the petitioner filed the present writ application without availing the statutory remedy. Stop. The remedy of appeal. Stop. Next, there being alternative remedy, statutory remedy of appeal, we are not inclined to entertain this writ application, as we do not find any exceptional circumstance. In the present case, this application is accordingly dismissed. stop. It goes without saying that the petitioner shall be at liberty to prefer appeal. He can
Yes, yes,
prefer appeal against the order which is impugned in the present proceeding. Yes. Next.
Item 10,
ऊपर भी देखो। वकालतनामा has been filed with the department. It has been stated by Mr. So that a वकालतनामा has been filed on behalf of opposite parties number वो दे रहा है so and so in the registry.
item 10.
May I please your lordship? If the petitioner are the employees of the Bhubaneswar Development Authority that challenge the notification under annexure 4, page 28, my lord. And in the similar matter, my lord has already rendered in judgment, my lord.
Yes. What is this?
The notification for pension rule, my lord.
Pension.
Pension. But in the same notification,
We
it has already
have
rendered in judgment.
extended to those who have joined
Prior to
2005.
2005. Yes, my lord.
15, 2005.
That is the.
They will be entitled
Yes, my lord. That is paragraph.
at par with the government employees.
Government employee. That is paragraph 82, page 72 of the judgment. So you will say page, paragraph 81, page 70.
For the other side.
No, development authority has to come.
Development Authority, the OPD part number 3.
The separate panel council.
Yes, they have separate panel council, but I have gone through that judgment. They are squarely covered. In
No,
fact,
but
the
we will
three-
have to hear. We will.
Yes,
In his
here-
absence, we cannot pass it.
Yes, my lord. Yes.
So you may be one of the parties,
Yes,
opposite parties.
the Development Authority,
Development authority is also one of the parties.
One of the-
OPD part number 3.
Part number 3.
Is there any standing counsel?
Mr. Dayananda Mahapatra normally appears.
He
We'll have a copy on him.
he usually appears.
It is stated at the bar that Mr. Dayanand Mahapatra, learned counsel, usually represents the Bhubaneswar Development Authority. Stop. Let's this matter on 1 week. Stop. The court requests Mr. Mahapatra to be present on the next date when the matter shall be taken up again for this court to consider as to whether the notices can be served upon him or not for expedient disposal of this case, considering the nature of dispute involved. And counsel for the petitioner shall be at liberty to serve upon Mr. Mahapatra 2 copies, a requisite number of copies of the writ petition by tomorrow.
Item 11.
May I please, your lordship? Lordship, this petitioner seeks indulgence of this honorable court as the petitioner is debarred for the second round admission. The petitioner is appearing the All India entrance test at annexure 4, page number 24, Milord, and logged his her choices as 6, but his her for provisional seat allotment was published on 23rd November
This
2020.
is regarding what?
The admission case in Ayurveda PG Ayurveda.
PG Ayurveda,
Miller.
whether the examination has been held,
This is an entrance examination was held.
then what do you want?
But our counseling was on that date with first choice was Kaya Chikitsa, but we are without providing the second round, we are selected as Rog Nidan. That is the option number 4, Miller.
So did you accept that?
Yes.
Then over.
Miller, actually there was provision when one seat is vacant, that will be upgraded.
That will be
upgraded. Means my choice was first one, that is the Kaya Chikitsa, and it is later vacated. For that reason, without upgrading my rank, the lower rank holder was got admitted. So
that can happen, but since you opted,
Yes,
you
yes,
must have
I
been
have-
admitted.
no, because this is chance. Because if you are not accepted the first round, then you are not participating in the second round or any other round. So it is mandatory to, if you have selected in a rank, you have to opt first. Then choice is upgradation.
Where is that?
Miller, that is annex number 6, page number 26, Miller.
Yes.
Yes, that's the last one is willingness details. Whether you, are you willing to upgrade your
Page
rank?
number?
26, Miller. Annexer 6, Miller.
Yes.
Yes, the authority taken the willingness of the candidate, whether are you willing to upgrade your rank? And our yes is yes, upgradation allowed. Float upgradation. If rank is, if any seat is vacated, then that will be upgraded in second round.
Just a minute. Which part you are reading?
Annexure number, page number 26, the last column, last line.
Last
Miller.
column.
Last
Willingness.
line, Miller.
Willingness details.
Yes, Miller.
There is nothing mentioned.
Float and right hand side is upgradation allowed. It's a computer generated provisional admission letter.
All right.
That is in November 23.
Yes, Miller.
So how can we allow you admission?
Because my lower rank holder got my seat and it may be exchanged.
You can go to Supreme Court for this. What is the last date for admission?
Last date was there was no such mentioning last date.
This is which course?
Ayurveda science. Postgraduate in Ayurveda.
The Supreme Court has fixed the deadline.
No, it is a commission. One is a Ayush Admission Central Counseling Committee.
For all such admissions. So you are relying on which part of the brochure?
Page number 31, Miller. The scheme. Willingness for round 2, R2. If yes, then display the newly added vacant seats and virtual vacancies. Choice submitted in round 1 will be treated null and void. Fresh choice submission for round.
Where are reading?
Page number 31, Miller.
Yes.
There is a flow chart of SEC PG Counseling Scheme 2023. That is the right hand side. There is a willingness for upgradation to round 2. If yes, what happened? If no, what happened?
Yeah. This portion. Willingness for upgradation to R2.
R1 round 2. And we are already allowed.
No, but the whole difficulty is that even if we consider your case, we cannot direct for your admission.
No, I don't want any admission because I am admitted, but I want only exchange.
You cannot. Yes, state.
Odisha state.
One of the opposite party 2 and 3 are, we who don't represent them. It is the
Who?
opposite party 2 and 3 who will be the answering opposite party here.
Who are they?
The OJE, Chairman Odisha Joint Entrance Commission, and the Chairman Ayush Admission Central Counseling Committee. We don't represent.
So what can be done?
Probably Mr. Subir Palit, Senior Counsel, and Senior Counsel, he appears.
Actually, Miller, the scheme was provided for round 1, round 2, and round 3.
Mr. Chief Counsel, we will have to hear them.
So I request Miller, please
Serve a copy.
short copy and stay this spot admission. Rather, it will be examination will be conducted on March semester.
Yes. How can you see? How can you pursue a course which you did not study? How can you pursue now?
So I pray for this one seat which is vacant. That
No, no. Why? What for? What for? See, you for whatever reason, you did not pursue that course. Could not pursue that course. So how can you be allowed to now?
Miller, I am admitted in another subject.
Mister, you are doing course A.
Yeah, Miller.
And you want your admission in course B.
Miller.
At the fag end of the academic session.
Miller.
Then what will you do? Except for failing in that examination?
Miller, may I please, Miller? Actually, Miller, at the time of counseling, it is mandatory provision that you have to opt 6 branches. So my first branch was.
So you want the dismissal of your case today itself? Because it is impossible. When is the academic session coming to an end? When will it come to an end? The academic session?
4 years. It is the first year only.
Academic year.
2023-24.
When is it? When is it coming to end?
No, it will not end now. It is
এই বর্ষটা কেবে সরিব?
July 2024.
So what will you do in 5 months or 4 months?
Semester would have been
March.
over and monthly tests, other tests would have been.
No, only semester. There are provisions of semester.
Unnecessary.
So we do not know, but what are the courses offered?
It will be an useless exercise if we entertain your petition.
Oh, please, see notice, please. Please issue notice and accordingly the decision will be considered.
This matter on Monday. So stop. Retiral counsel for the petitioner serve a copy of the serve requisite copies of the petition on Mr.
Subir Palit, learned senior
Subir Palit.
associate tagar ki.
Senior Counsel Mr. Subir Palit.
Who is his junior?
A
He
Mishra.
is a senior counsel.
Amitabh Mishra.
Amitabh Mishra.
Amitabh Mishra.
On Mr. Amitabh Mishra, who appears usually on behalf of Orissa,
Opposite party number 2, my.
opposite party number 2. All right.
Ayush is something different.
I will start. We have opposite party number 3 is all totally different.
Yes, next.
Obligement.
Item 12.
Yes.
May it please, Your Lordship. As a contempt application, the state has filed a compliance affidavit, my lord. However, there is not the compliance is not complete, my lord. In respect that after the direction of this honorable court, within the time frame, no action was taken. The action, the state machinery came into action only after the filing of the contempt application. After the contempt application, they have issued notice. The encroachers have been found to be in encroachment of the Gochar lands, my lord.
All right, so they have done something.
My lord. However, they are still.
It is admitted. It is an admitted position that this court's order violation of which has been alleged in the present contempt application is being complied with by the contemners, though belatedly. Stop. Next. When counsel appearing on behalf of the petitioner has submitted that the failure on the part of the contemners to comply with the order within the stipulated time constitutes contempt of court. Stop. Next, however, considering the subsequent conduct of the contemners, we are of the view that no case is made out of willful disobedience of this court's order. Stop. The contempt proceeding stands dropped accordingly.
Obligation. Item 13.
Item number 13.
The order has not been
The contempt I'm replying, Lordship, we are directed to comply the order by 28th March, and by 28th March, we have complied the order almost fully. We have reinstated him in the post of lecture A with effect from 2003. 16,000 has, 16 lakhs has already been released in favor, and he is entitled to still some more amount, which we will calculate because he had worked at different places. For that, we need 15 days more time, I filed the affidavit, in course of the day today, may kindly go through. 15 days, we will comply it fully,
AGA appearing on behalf of the contemners has submitted that this court's order, violation of which has been alleged in the present contempt application, is in the process of being fully complied with. So he submits that part compliance of the said order has already been done, in as much as the petitioner has been reinstated.
My lord, I am contending there is no question of reinstatement.
No, reinstated.
That wrong word has been used by my lord.
He has been treated as lecturer A, which is from 2003, and area has been paid.
Petitioner has been treated as
lecturer capital A,
Group A,
capital lecturer
Group A,
Group A.
My lord. With effect from
2003.
With effect from 2003, the direction was to pay him, but that payment has not been made. And the fixation in reader scale has not been made.
And part consequential payments have also been made.
Payment, my lord, payment has not been made.
We are reporting his submission.
Oh, bless. Oh, bless.
So he submits that the petitioner has been found entitled to some more amount, which shall also be paid within 15 days. Stop. List this case on 3 weeks.
I'm serving a copy which I am in favor in course of
Give whatever.
Sorry. I will fix a date.
We have fixed a date.
Okay.
Item 14.
In 14, notice has already been issued, as it appears from the noting that he had died in the meantime.
Who?
Opposite part number 1. So I'll file an application for substitution.
Item number
14 and 14.
Lordship, there is a noting in the list, my lord. Undelivered notice returned from respondent number 1 with report Radesi expired.
Then you
I'll file a substitution to that effect.
and AGA representing the appellant seeks adjournment to file an application for substitution consequent upon death of opposite party number 1.
My lord.
Respond number 1. Stop. has requested list this matter on 3 weeks.
Well, item number 15.
Some defect is there in item number 15. I will remove the defect in the in time.
How much time? How many years will you take?
My lord,
How many years for removing the defects?
next
Next year.
next week I will.
So that was granted on 2023.
Such my lord, dude. I couldn't obtain the certified copy from client.
Certified copy. So without obtaining certified copy, you will not remove the defect. What is this?
And other some instruction required kindly. Next week any day.
Two orders have already been passed. Sorry. Despite repeated orders of this court, the appellant has failed to remove the defects. This appeal is dismissed for default. Yes.
Item 16. Item 16, my lord, last occasion, lordship has directed me to furnish the all numbers of similar cases. I have furnished it to the court master, my lord.
How many?
I have already the 17 numbers. I have given, and I also am giving that on that day I have
Similar or same order?
similar, same.
Issue is same or order is same?
Issue is same. Orders are different.
What is the issue?
Issue regarding that regularization of pharmacists working under medical health unit, mobile health unit. They have relied on judgment of state administrative tribunal that has been confirmed by here and confirmed before the Honorable Apex Court. But our case, they are not, they don't stand with same footing in that Amit Mishra case. This is the case, and I'll file an affidavit to that effect because in my writ appeal, all the documents that circulars and the order.
Yes, these cases are similar.
My lord, I don't know whether these cases, but the today's cases listed before your lordship.
Three matters are similar.
Matters are similar, and that identical issue, only the district is different. The identical issue has been passed by the judgment passed by the tribunal, has been confirmed by your lordship division bench, cardinal bench. Thereafter, Apex Court has honorable by region order, their lordships of honorable Apex Court, and that has been implemented since long, 2 years back.
Right.
So relying upon that judgment, the single bench has passed the order, and that has been challenged before your lordship.
And
Yes, my brother.
one more thing, I am in the second matter, Millards. I would like to bring to the notice of this kind, Honorable Court, Millards, that the similar writ petition where the similar impugned order is there, that has been full-fledgedly heard by one of the Honorable Bench of Honorable Judge Justice A.K. Mahapatra, and that matter has been heard and order is reserved. And this is similar to that also, Millards.
Shall I clarify?
I could not follow.
My lord, in some of the cases that has been processed and the single bench has passed because these cases, my lord, previously before the learned OAT tribunal, subsequently transferred to that this honorable court and the honorable single judge has passed, the writ appeal has been prepared. Other cases, my lord, about 100 cases, the same issue, they have challenged approach before the honorable single judge in the first instance. And in those cases, the order was reserved.
Order has been reserved.
The order was reserved. But in these cases, the honorable single judge has already passed. So that is why my brother has preferred the writ appeal. And in some 3 district cases, the identical issue is already implemented and pursuant to the order of Honorable Apex Court.
Has been stated by Mr. By learned AGA that AGA representing the appellants that writ appeals involving similar issue similar stroke, same issue are pending before this court, which may be heard together. Well, so he has supplied a list of such appeals. Oh. In view of the submissions so advanced, on behalf of the appellant, list these appeals on next on 12th of March.
Mine. Problem.
To be taken up at 2 p.m.
My lord, copy of the writ appeal today's matter and
I'll serve.
we solve.
I'll serve in course of the day.
Because in the most of the cases, about 2 years delay is there. So I will.
Item 17.
My lord, in this case, 2 writ petition, common judgment was passed. Therefore, 2 appeals have been preferred. Today, my lord, writ appeal number 2432, 23 HCom, that with IN number 733 by 24, that is for
This is item number 17.
IA 733 by 24, that is a limitation condonation of delay, 1 day delay. So, arranging out of common judgment 2 writ appeal, another writ appeal, my lord, 2433 by 23 is there. That may come along with that petition, writ appeal.
List this delay of 1 day in preferring this intra-court appeal is condoned. Full stop. It has been pointed out by the learned counsel for the appellant that another writ appeal, that is WA number 2433 of 2023 has been preferred against the same judgment and same order of the learned single judge, which is under challenge in the present appeal. So stop. List this case on 2 weeks with WA 2433 of 2023.
Obliged.
Item number 18.
But item 18, I have served as directed by my lords by order 26 to 24. I have served the copy of writ appeal, and the affidavit, my lord, is being sworn in today. I will file the affidavit tomorrow. It's being sworn in today. The affidavit has been made ready. It's being sworn in today. Affidavit with my additional documents. The orders, my lord, so that they heard it to some extent. So the orders of the Honorable Supreme Court and orders of the coordinate bench, single bench of this Honorable Court and an order of the tribunal. All these orders I will be filing with an affidavit. That affidavit is ready. I'll file.
Yes.
I am for the respondent. I am for the respondent.
All right, as requested on behalf of the.
Please to hear this case because the Advocate General will address.
Oh, that matter.
No, this is
That is about work charge employee.
This is that was worker. This is the job contract.
This is
job contract.
Job contract.
Job
job
contract.
contract, as requested on behalf of the appellant, so as to enable him to file an additional affidavit. List this matter on 1 week.
Item 19.
19 letter to state. 19.
Here is a delay of 323 days.
320.
Permit, I will take note.
323 days.
If Marrow's permit, I will take notice.
In 23 days.
300.
So what do you want?
I will take notice, my lord. If they file objection, then my lord may hear on. If my lord find.
I was party to the earlier bench.
My lord.
I was party to earlier bench where state's appeals
My lord.
of inordinate delay were being
My lord.
rejected.
My lord.
What is your explanation?
My lord, that we have said that because after receipt of necessary advice of the law department and the file.
And what is this matter about?
My lord, the order dated 24/2/23 at page 23, that is under challenge. The order of regulation, my lords have directed. And we have said that they do not meet the requirements of the 27/9/13 G department circular. If my
Then we
lord
are
senior is
discussing your,
my lord,
we are rejecting your this condonation application.
may I pray subject to my lord's acceptance? May I submit my lord subject to my lord's acceptance? My lord, since my lord senior is appearing, he is there. So my lord may hear me on
Assistant
on
driver.
imposition of cost. my lord.
Assistant driver, you fight for their cause.
I am aware, my lord
You
may
have
also dismiss my case on merit. So on imposition of cost, my lord may allow me and decide the matter.
1 crore?
My lord,
1 crore?
I cannot say that, my lord.
Where you can afford? If you go to Supreme Court, you will be spending that much of amount.
If you see,
I leave it to my lords.
So he may pay 1 crore, we can.
Counsel, you could see page 28. The observation is the petitioners were appointed as assistant driver on contractual basis with a consolidated remuneration of 5,200 per month for a period of 1 year. Continue. 5,200 rupees you pay. And
Your IA limitation is 593.
My lord, the IA is 593.
Yes. This intra-court appeal is time barred. There is full stop, there is delay of 323 days in preferring the appeal. IA number लिख देना, IA number 593 of 2024. This application has been filed for condonation of delay. Full stop. Following is the only explanations given in the petition seeking condonation of delay. Why have you mentioned only 30 days delay? Paragraph 4.
My lord, the order is, my lord will see the order is 24/2/23. And I have filed the appeal on 15/2/24.
yes, that's why my lord asks you.
Why have you
Para
mentioned?
4, you have mentioned that in view of the above. The para 3 says 3/2/2024 you have come up in appeal, you have filed the appeal.
My lord.
But in para 4, you have said, in view of the above, there is a delay of about 30 days.
No, it's
All right. Paragraph 2 and 3 court cover. So we are satisfied on the basis of what has been asserted in the limitation petition that the appellants have not at all been able to explain that they were prevented by any reasonable cause because of which they could not prefer the appeal within time. This appeal is hopelessly barred by limitation. Without, in the absence of any explanation, comma, this application is dismissed.
Item 21.
Resultantly, the appeal also stands dismissed. Resultantly, WS1 so stands.
Wait, please, Your Lordship.
21.
Yes.
But the petitioners, they have filed the writ application. And prior to the filing of the writ application, the ex-service holder, army personnel, Jawan, who filed a writ application before this honorable court, inter alia making a prayer that he has been allotted 5 acres of land by the Tahsildar as per the lease principles of the government on the basis of the recommendation of the Home Department.
But this writ petition is of 2013. We are in 2024.
No, sir, writ application was filed earlier by the father, person who was the ex-serviceman. During pendency of the writ application, he expired. Then the legal heirs were substituted in 2012. When the matter was taken up, the Honorable Court wanted the subsequent events you have to incorporate. He granted a leave to withdraw the writ application and filed a fresh one. That is the reason why a fresh writ application has been filed. So it's not a new one. It was a continuation of the previous one with the liberty to file. So the legal heirs after the death, they filed the writ application. So they say allotment has been made. Let's kindly appreciate. Allotment has been made. They could not give delivery of possession. So they say, since I'm entitled to on the basis of the government circular and the government Home Department direction, now the land which you have allotted in favor of my husband should be given to me to identify. So they themselves verified that the records are not available with us. So that is the reason why we filed the writ application, that it is there. If your lordship looks at, I have had an additional affidavit. In the additional affidavit.
No, where is the scheme?
The scheme is there. If your lordship looks at, kindly see. On the basis of the scheme, it was allotted, my lord. And the record of right has been given. He has paid the rent also. This is from way back in 1963. These are all extracts from the lease principle.
Where is that? You are relying on which?
If your lordship looks at page 367, the person who are to be considered for the purpose of grant of the lease. Personnel of territorial army belonging to Orissa posted in the forward areas. Personnel of the
when did he die? When did the personnel die?
Person died in 2012.
And when was the land allotted?
Land allotted much before that.
When?
That was, I think, in 19. I'm extremely sorry. Just 1 second, Lord. It was allotted 5795.
5795.
Annexure 3, page 14.
Till his lifetime, did he raise any dispute or raise any grievance?
No. During his lifetime, he says that you have already allotted a land in my favor.
No. Land was allotted in 1995.
Right.
He died in 2012.
Well.
So whether during his lifetime, the personnel had ever raised any grievance before any authority that, see, this land was allotted to me, which should be handed over to me.
Yes, he himself filed.
Where is that?
Yes, brother. Kindly look at it. He himself filed. Kindly turn to paragraph 8 and 9 method.
And where that allotment is heritable.
Annexure 3.
Annexure
Oh,
3.
heritable leaders.
Yes.
But because they give the Jawan lease as per the government lease principle to the Jawan as well as the legal heirs.
Where is that?
It's there. It's there. And all leases are heritable and transferable for one High Court decision. That there are 4 types, 5 types of lease actually.
Yes, yes.
Khasmal, Nazrul, and the Gramakantaka, Parambako.
Yes, yes.
These are heritable. This right is created in favor of party.
So this is for the purpose of cultivation.
Sir?
The lands are allotted for the purpose of cultivation only.
Cultivation.
No, for no other purpose.
No, it's for cultivation, for development, and then for their.
Oh, no. So
For cultivation.
For the purpose of cultivation.
For cultivation, my lord.
Yes. Yes, where is that?
Yes, paragraph. But paragraph 10, if you also look at, while the matter stood thus, Prasanna Das misplaced the
Paragraph 10 of what you have given us.
Paragraph 10 of the rate application. Nine and 10, both, if your lordship looks at, 9 I am reading. It is humbly submitted that pursuant to the order passed by the Tahsildar, para 9 malad at page 4. It is humbly submitted that pursuant to the order passed by the Tahsildar, Pata was issued in favor of Prasanna Kumar Das in respect of Sabik Khata 537, Sabik plot 789, corresponding to Hal Khata 516 by 284, Hal plot 798 by 2896, measuring an area of 5 acres in Puri Tahsil, erstwhile Brahmagiri Tahsil. It is relevant to note here that 5 acres land allotted in favor of Prasanna Kumar Das was not demarcated, and no physical possession was delivered in favor of the father of the petitioner in respect of the land in question at relevant time. When approached by the applicant, Prasanna Kumar Das, the Tahsildar and official informed him the land will be identified and demarcated. He raised the objection to the relevant time, and that was pending with the authority. He died. He filed a writ and he died. Then they are substituted. Now this is the writ application where you also instructed them to obtain instruction. They did not file any document to that effect. No, nothing has been given. I filed the additional affidavit, but we kindly have one document in the additional affidavit. Page 25, Marad, in the additional affidavit.
Yes.
This is the record of right of Brahmagiri Tahsil, because their instruction is that now the Tahsildar has been bifurcated and the Tahsildar of Puri has been done in Brahmagiri Tahsil. In Brahmagiri Tahsil,
Which is this additional affidavit, internal page 25?
Yes, internal page 25.
Internal page 25 is?
Annexure 7. Annexure 7.
Annexure 7, yes.
I'm sorry that it is in here. It is Khatian, this record of right. But kindly turn to the next page. The plot numbers are given where the right side mentioned all Odia Jaban Manago Pai Sangra Kita. That's called reserved for the army personnel. All these plots are reserved. It is their government record.
So that question remains whether the right is heritable or not.
Land is heritable in the sense, if you also look at the circulars I have given to you also, government circulars. Kindly have a look at the circulars.
Yes.
This circular itself says paragraph 3D, that next page, or second page. Paragraph 3D of the Government Home Department prescribed for each person on return will get 5 acres of land made ready for cultivation by government. Government consider ward on return will great extent handicapped persons having served regular army are normally accepted to return to retirement. It has been decided to amend the said resolution that allows such personnel Air Force completion 5 years of service, and kindly turn to the next page. Their legal heirs are there. The legal heirs. I'm sorry, the second page D. Each person on return will get 5 acres of land free, made ready for cultivation of government cost. In case a person is killed, his widow and dependents will receive the land.
So that is not the case.
And then paragraph 2 also, in consideration of risk and sacrifice of officers and men who have proceeds and will proceed to forward areas for active service, the state government have the pleasure to decide that following categories of persons, their men will be entitled to facilitate detail below, provided they are unable to manage with
No, where are reading?
and their family members desire to have availed themselves. Also the family members.
No, that is different. That is different. Family members can be settled.
But I'm asking a question to myself in one word. If a land has been settled in my name, if I die, the legal heir should succeed. This is heritable and transferable. All leases are heritable and transferable.
We'll keep that. All right, we will decide.
After lunch?
No, we will decide it.
But actually, the government was directed to give the decision there.
Based on your amendments.
Yeah, I want decision you should kindly take note of. That yes. No, like all leases actually, it is heritable and transferable. But paragraph 4, it is there. All documents are filed and pleadings are there. Grateful.
Yes.
Reach today, the students have to appear the exams. Any day, your lordship pleases to give me some priority any day.
It will be listed automatically tomorrow.
Tomorrow. If we can, I was only praying that if your lordship gives me some priority tomorrow.
I'll make a mention in the morning.
Grateful. Grateful.
Item 48, senior counsel was engaged for the petitioners. He had some mishap in his family. The senior counsel, mishap in the family of the senior counsel engaged. I prefer Monday, my lord, only.
What happened?
My lord, the death in his family.
Yes.
In his family, my lord.
Yes.
Lord, actually, senior counsel's inconvenience. I
Only
understand.
Monday, my lord.
There, our petition for post, my lord, may kindly take up on Monday.
Monday requested on behalf of the petitioner on the ground of inconvenience of senior counsel. List. One matter or how many matters?
One matter. Because of
Monday.
at 2 p.m. my lord.
Monday 2 p.m.
2 p.m.
Interim order to continue, my lord.
2 p.m. Then we can take up this matter on Tuesday. Huh? Tuesday.
Here the problem is that the interim the order of the single judge can be worked out. There are vacancies lying in the.
Yeah, I was exactly praying that subject to because he's not here, my lord, senior is not here. My lord, there are 5 petitioners. posts are, my lord, more than 35. I was praying this honorable court, my lord, may keep 5 posts.
Vacant.
And rest, my lord, may allow us to fill up.
My lord, kindly, the government has filed an IA, my lord. That IA, my lord, the prayer in the IA, we have no objection. If that IA is allowed, then we have no objection. And kindly see the IA of, filed by the government.
What is that?
That the DPC held on 23, 2023. They have prayed for to give appointment on that result of that DPC, subject to result of the writ application, writ appeal. That we have no objection.
Here, I'll advise my lord.
I have one
What
submission.
has happened? We have succeeded before the honorable single judge. This is a matter pertaining to reservations in promotions. Now, my lord knows Indra Shawnee in 93, para 700 clause 6, it said that there should not be any reservations in promotions. The government wanted to get over that. They came about with constitutional amendments. Nagraj held those amendments to be intra vires. While holding them to be intra vires, they said that the state has to conduct specific exercises. UP power, they said that unless you conduct those specific exercises, you cannot have it. The honorable single judge notes all this and says that since you have not conducted this exercise, now in Orissa, my lords, one matter went to the Supreme Court. There they said that Orissa has not conducted this exercise. So as we stand today, this exercise in terms of M. Nagraj hasn't been done for the state of Orissa. Single judge takes note of all of this and says that the reserved candidates in terms of Ajit Juneja cannot march ahead of the general candidates. And the honorable single judge says that post January 1st, 2024, these writ petitioners can also be accommodated and a fresh exercise can be done. So all that I was praying, my lords, let these 5 appellants remain, 5 posts be kept vacant, and the order of the single judge as would appear from para 21 of the impugned order, let it be given effect. Because here we are suffering an ex parte order of stay regarding the order of the honorable single judge.
What I pray, my lord.
Now, my lords, we are looking at constitutional judgments being violated.
My lord, if that will be held, my lord, since the matter is finally to be heard by next week, any date of next week.
No, we don't know when the matter will be heard. We are ready to hear this matter today. You are not ready. What will happen to us, we don't know on the next day.
I don't understand, my lord. There is some.
A very fair stand has been taken that you are 5.
My lord, kindly see the IA filed by the government, my lord.
Sir Counsel, you are 5.
Yes, my lord.
So can you have 7 seats?
No, my lord.
So if for you the posts are kept reserved.
What my humble submission is, if only 5 seats is reserved and fresh exercise has been done, then the DPC held on 23, that will become redundant. So therefore, the prayer of the government is correct that you give the reserve promotion as per the 23, and that will be subject to result of the writ appeal.
Why 23?
That
is already a DPC.
This DPC was held before the honorable single judge order. So now, the learned senior Mr. Mishra says the correct proposition, my lord. My lord may allow us to go ahead with keeping 5 posts. Whoever are eligible, we will promote them and we will keep 5 posts. If they succeed, they will get promotion.
My learned senior is submitting against his own application.
No, because
my lord, kindly see the prayer of their application.
We may submit, the order has to be passed by us.
My lord. My lord, difficulty is that, my lord, if 5 is given effect to.
May I just submit? If what he is saying is allowed, then that will be in the teeth of several constitutional bench judgments, including Jarnil Singh.
Here the case is that there is no principle of reservation has not applied to the promotional post. That is the case here.
Yes, cannot be applied.
Not applied.
Cannot be applied.
Government has not applied.
Cannot be applied.
They are now coming.
In the meanwhile, though the state respondents shall be at liberty to proceed with the DPC, proceed with the matter relating to grant of promotion. Meanwhile, the DPC may proceed
My lord.
with the matter of promotion, comma, 5 posts shall be kept reserved so as to protect the interest of the appellants.
My lord.
Top. It goes without saying that any action of the respondent shall be subject to final outcome of the case. What else do you want?
My lord, that is good. Can we put
So
the next?
you have got 2 orders. 2 orders in your favor. 1, 5 posts reserved. 2, any action subject to final outcome.
My lord. I can do next week any date, my lord.
Next week, yes. No date, any week.
7th March.
7th
So
March
at 2 p.m. my lord.
at 2 p.m.
May I just submit that DPC in terms of para 21 of the Honorable Single
In
Judge?
terms of para 21 of
of
the
Honorable Single Judge.
decision rendered by the learned single judge
We are all great.
in the order dated learned single judge for
We are all grateful.
Item number 22.
Anyway, excuse my lords. Item 32 minutes in the list today. The matter was heard, judgment was reserved but could not be delivered. And again, it has come before a lordship after a call of time. Will your lordship be pleased to allow us 7 days time to call it?
Let the matter be called. Ask someone to be here when the matter is called. We will solve that. Yes,
Item 22.
May I please, Your Lordship? Your Lordship, the petitioner is challenging the order dated 27/1/2012 passed by the learned State Administrative Tribunal in OA number 1759, wherein, Your Lordship, the prayer of the petitioner challenging the order of termination from the service was challenged and the same was dismissed by the Honorable Tribunal, Your Lordship. Your Lordship, on the grounds that the Tribunal dismissed the pleas, have actually been in fact dealt with and decided in an order of this Honorable Court, Your Lordship. Lordship, if I may pass
Where is the
judgment.
order?
Your Lordship, passing on the judgment. Your Lordship.
No, where is the order of the tribunal you are challenging?
Annexure 7, Your Lordship. Your Lordship, the fact of the case is that the petitioner was appointed as the additional section teacher in an aided school, which was subsequently taken over by the government, Your Lordship. Your Lordship, the petitioner was appointed in the year 1990 when the qualification, minimum qualification of B.Ed was not an eligibility criteria, Your Lordship. Later, Your Lordship, the petitioner was also
Similar matters were taken up earlier.
Yes, Your Lordship.
Similar
matters. Who matters?
No.
No.
Vivekananda Das.
That's a different issue.
Different issue.
Your Lordship,
Please.
The post of the petitioner was also approved by the government, and so also the petitioner was approved as the additional section teacher, Your Lordship, as it can be found in Annexure 4. Annexure 4, Your Lordship.
Section teacher.
Yes, Your Lordship.
What is this?
The strength of the students. Go beyond the
Acha,
particular
there is
level,
additional
and
section.
additional section is
Yes.
Here, Your Lordship, if Your Lordship may kindly refer to Vivekananda Das judgment, Your Lordship, I have just passed.
What are the facts of your case?
Your Lordship, later on, the petitioner was terminated from the service, holding that B.Ed is a compulsory criteria. Your Lordship, he was in 2001, Your Lordship, that is in Annexure 6.
Yeah.
Your Lordship, if I may refer to this judgment that I have placed before your Lordships. Paragraph 5, your Lordship, clause I. While dealing with similar cases, your Lordship, it has been held that during the relevant time, an untrained graduate teacher was eligible to be appointed as an assistant teacher in a non-government aided high school. He was not eligible to receive trained graduate scale of pay. Untrained graduate scale of pay, however, was admissible to him. The applicant being a pre-1993 appointee, his appointment cannot be disapproved merely because he does not possess the training qualification B.Ed. Your Lordship, further, paragraph 6.4, your Lordship. May I please, your Lordship?
Yes.
Paragraph 4, your Lordship. In para 11 of the judgment, this court has recorded a finding that the state government has already approved the post with petitioner's name against additional section in Pipili High School, Pipili, which is a matter of fact. That being the finding, there is no further scope to hold in the impugned order that the name of the applicant had not been listed for approval of this appointment. The court, while allowing the writ petition of the applicant, quashed the office order number 1657 passed by the Inspector of Schools Puri, and he was directed to approve his appointment. In obedience to that direction, the Inspector of Schools has in fact passed an order approving his appointment after having complied with that direction. There is no further scope to go behind that order, your Lordship. Similarly, your Lordship, even the petitioner has got approval from the state, your Lordship. Your Lordship, my submission is that once the post was approved and he became a government servant, whether I impose a question on myself, your Lordship, whether the state can abruptly terminate the petitioner without following any procedure as per the statutes, your Lordship, only on the basis, only on the garb of some condition that was placed for appointment, your Lordship.
Subsequent to your appointment.
Yes, your Lordship.
Condition subsequent to your appointment.
Yes, your Lordship. My appointment was in the year 1990.
So when this qualification of B.Ed was introduced?
In 1993, your Lordship.
1993.
Yes, your Lordship. And your Lordship, similarly placed candidates also approached the tribunal, and they were directed, it was since they did not receive the approval, your Lordship, initially, they approved the tribunal, wherein the tribunal directed that such approval, not passing such approval is illegal, which was later not also was also challenged in the writ petition and was dismissed. Subsequently, also SLP was filed and it was also dismissed, your Lordship. So they are now, even being untrained, your Lordship, they are presently in the department in service, while I have been terminated, your Lordship.
Yes. So first of all, tell us whether this case is covered by this decision or not.
No, that has been overruled by another case, that is Nobin Bora case. I'll just that reference, that 2011 OLR.
This judgment has been overruled.
Yes, madam.
By a larger bench.
No, by two bench, madam, distinguished.
How are two bench?
Distinguished. How that is not in the facts and circumstances. Not. But before that, I will draw my Lord's notice only one document, my Lord.
No, but where is the overruling? So is she correct that if this case is to be followed, then she is entitled for the relief?
Yes, ma'am. He's not correct. She's not correct to that effect. Only
No, you are using the word overruled.
not
In fact, it is not
distinguished.
overruled.
Sorry.
Clarify.
Distinguished. The facts and circumstances that distinguished. I'll show my Lords only one document, and basing on which termination order has been passed. The Lords may see his approval order. What is his claim that he has been approved, so he cannot be terminated without any procedure followed under CCA rules. The Lords may see annexure A/3 to my counter.
No, but even otherwise, you must have some valid reason for termination.
Yes, that I am coming, my Lord. Why he has terminated? Yes, that what is the valid reason that I am coming? Lords may see my annexure A/3 to my counter. His approval order. Lords, you got it?
Your counter, when did you file?
Your A/3 is copy of counter file.
Counter?
It is not approval.
Yes.
Counter filed before the state administrative tribunal.
Yes, 6/10/2013, 17. I have annexed the counter file before the state. Your Lordship, my counter is filed on 6/10/2017. What was the stand before the state administrative tribunal?
No, counter filed by opposite party number 4.
Yes.
District Education Officer.
6/10/2017. Yes,
6/10/2017.
my lord. Your Lordship has pointed that counter filed by District Education Officer opposite party number 4. That is the counter.
Yes.
Your Lordship may see annexure A/3.
Yes.
This is the approval order.
By 3 page.
Page, my lord, that's not been normal.
Page 11, Your Lordship.
Page 11 of my counter, internal page.
Yeah, you are.
Here, but
Counter is
in
not
my
on-
counter filed here, I have annexed one counter of the which was filed before the state administrative tribunal.
Yes, only one counter is there with us.
Counter filed before the tribunal.
Yes, my lord. That has been annexed here, my lord, in my counter here also. The stand which were taken before the tribunal, that counter has been filed here also. Your Lordship may see the annexure A/3, page 11.
Oh, A/3 to the counter.
Yes, to the counter filed before the state administration. Your Lordship got it.
Yes.
In pursuance of GO number
44.
Yes, please.
in pursuance of GO number 12631 SME dated 29/4/95, GO number 19161 dated 31/7/96, read with Directorate letter number 9783 dated 22/2/93, and without prejudice to the claim of others, the appointment of the following trained, untrained additional section teachers made by the concerned managing committee of the said schools noted against each are hereby approved with effect from 7/6/1994 in the prescribed scale of pay as detailed below. They should acquire BEd training within 2 years from the date of issue of this order, failing which approval will be cancelled automatically.
So this he did not.
Yes.
He did not acquire.
See, he did not acquire that qualification.
Yes,
This is a
Your
condition, sorry.
Please, please.
So this is a condition of the approval. You have to acquire BEd qualification and he has not challenged this.
2 years from the date of issue of this order. That
Yes,
is
ma'am.
12/6/1990.
98.
98. Yes.
And what is the effect of non-approval?
If his post is not approved, then he will be a staff of that private management. He will not get aid from the state government.
How do you say?
Because only posts which are approved and those who come within the yardstick prescribed by the state government, those posts will be approved and those posts will be come to the fold of granting aid.
You are making this submission on the basis of some document which you might have read.
Sorry, sorry.
Where is that?
Sorry, man. That I will give all those documents before my lords so that your lordship can go through the document.
All right. So according to you, this is the seat anchor of your submission.
My lord.
This annexure A/3.
My lord.
That the appointment was not approved.
Her appointment was approved with a
No, her appointment because he could not acquire B.Ed qualification.
his approval was cancelled.
Cannot be said to have been approved. No,
Yes.
no cancellation.
No, this was approved.
Hereby approved, telling which approval will be cancelled. So two automatically cancelled. This is your submission.
Yes, ma'am. In 2001 we have cancelled. After 2 years.
No, even without cancel.
Yes, ma'am. Even without cancel, it stands cancelled.
Stands cancelled. So this is your submission.
My lord.
And this is your only submission.
Yes, ma'am.
But one doubt, page 21. The same letter has been referred to in 2001.
Yes, that has been
Inspector of
cancelled.
Schools, page 21, Annex 6.
Yes, ma'am.
That's 6 to the main petition. Page 21.
21 of the main petition.
That is the subject matter of challenge.
No, there. 12/6/1998. Letter is referred to.
Yes.
Which you have read to us.
Yes.
Your annexer A/3 before the tribunal.
Yes.
But something else is written also.
No.
The services of so and so, who has been appointed as additional section teacher by the then managing committee of so and so high school by letter number such and such, is hereby terminated pending finalization.
Of a decision of OA number so and so filed by Sri Pradhan. Sri Pradhan
As he has not complied with the condition imposed, such and such to acquire B.Ed.
B.Ed within 2 years.
Within 2 years with effect from the date of issue of this order.
Yes.
So OA number 1759C of 2000.
He has filed that OA.
What happened in that case?
Your Lordship, that was pending when I was terminated, and that I had filed challenging the office order.
That was
is-
pending before the tribunal.
Yes,
What is
Your
the
Lordship.
status now? It would have been come
It was
to
disposed of.
this court
It is disposed of by this common judgment, Your Lordship.
by a common judgment.
Yes, Your Lordship. That has been challenged.
And then what remains? What happened to that? That is what my lord asks you.
That was dismissed, Your Lordship. That was.
Where is that?
It is by this common judgment.
Since your application was
Annexure
dismissed,
7.
how do you now contain, in view of what was being shown by Learned Counsel, that your service was not, your appointment was not approved?
Yes, Your Lordship. I have two submissions, Your Lordship. First is that the ratio decided in Vivekananda Das case, Your Lordship, clearly, if at the time of my selection, Your Lordship, if that was not the criteria, then I may be allowed to continue in the untrained teacher section, Your Lordship. I'm not asking to be employed as a trained teacher, but as Your Lordship can see, Your Lordship, paragraph 5(1) that I read out, Your Lordship. During the relevant time, an untrained graduate teacher was eligible to be appointed as an assistant teacher in a non-government aided high school. He was not eligible to receive trained graduate scale of pay. Untrained graduate scale of pay, however, was admissible to him. The applicant being a pre-1993 appointee, his appointment cannot be disapproved merely because he does not possess the training qualification. That is my first submission, Your Lordship. And second is that, Your Lordship, if Your Lordship may kindly turn to the counter filed by the opposite parties, Your Lordship. Paragraph 11 of the counter. They had submitted that it is humbly submitted that it has been stated in the counter filed before the learned tribunal that the name of the petitioner was sponsored for undergoing BA training during the session 2000-2001 for consideration of SCRT, but the petitioner did not take the opportunity to get himself trained. True copy, Your Lordship. To this effect, in my rejoinder, I have already annexed that I had applied to be, since Your Lordship, B.Ed is a full-time course and I was already in my full-time job. And since there was an opportunity wherein sponsorship was being given by the department to continue the course, I had applied, which was duly acknowledged. However, no response was given to that. And immediately thereafter, I was terminated. So, Your Lordship, this stance of the government is not acceptable, that I did not take endeavors or I did not go for training, Your Lordship. In fact, I have tried, but there was no response from the side of the government, Your Lordship. And I have annexed it in my rejoinder.
If I have understood your submission correctly, your submission is that your appointment as B.Ed teacher, trained teacher, might not have been approved.
Yes, Your Lordship.
But your appointment as untrained teacher ought to have been approved.
Obliged, Your
Or
Lordship.
should be considered to have been approved.
Obliged, Your Lordship.
This is your submission.
As per the ratio decided in the Vivekananda Das case, Your Lordship.
Vivekananda's case. So your claim is that the cancellation of approval
Yes, Your Lordship.
pursuant to that annexure 6 or what?
Annexure 6, Your Lordship.
Annexure 6 was only with respect to your appointment as trained teacher,
Yes, Your Lordship. For not
Be a
obtaining the
teacher.
training, Your Lordship.
for not obtaining.
And Your Lordship, no procedure was followed as I have already submitted before Your Lordship. Only on the garb of the opportunity, Your Lordship. At one hand, they purported to give me the right by approving with this condition. On the other hand, it was taken away as it was impossible for me to pursue it without
No, that is different. That you accept. That you accepted. You are appointed. You did not have B.Ed qualification.
Yes, Your Lordship.
According to you, at that point of time, there was no requirement of B.Ed qualification.
Yes, Your Lordship.
Subsequently, B.Ed qualification was made mandatory.
Yes.
In that background, your service was approved, but subject to condition that you acquire B.Ed qualification within 2 years.
Yes, Your Lordship.
Failing which, the approval shall stand cancelled automatically.
Yes, Your Lordship.
You accepted that.
Yes, Your Lordship.
All right. So how can you challenge the correctness of that decision? And therefore, we were trying to understand what is the effect of, what is the consequence of cancellation of approval.
Your Lordship, it becomes disapproved, Your Lordship. That means
Becomes disapproved. Then in whether if it becomes disapproved, then can you be allowed to continue?
No, Your Lordship. Your Lordship, I may be allowed to continue, but it will not come under the purview of government, Your Lordship. It won't come under the power of government. I won't be a government official, Your Lordship.
So this is what he is also saying.
Yes, Your Lordship. To that, I have submitted that I should have been considered as an untrained teacher, at least, Your Lordship. Because since it was not mandatory during when I was appointed, and I have been appointed with due procedure at that time, Your Lordship.
Due procedure, you were appointed, but you did not stake any claim for your appointment as an untrained teacher, non-B.Ed teacher.
In your prayer, you are asking for us to modify the government order
No, Your Lordship,
and reinstate.
I'm challenging the tribunal order wherein it has been dismissed. Subsequently, the government order wherein I have been terminated, Your Lordship.
What about this paragraph 5?
Mr. Khuntia, you have said that this judgment is distinguished.
Not what has happened, my lord. In Nobin Beura case, a stand was taken prior to 1993, as there is no provision for appointment of B.Ed was not the mandatory condition for appointment as a school teacher. So, Honorable Court had directed to approve them against the untrained post.
Please come to paragraph 5. Paragraph 5 is not the decision in case of Vivekanandas. Paragraph 5 refers to some order earlier passed by the court. Earlier it was called OJC number.
Yes.
Huh?
OJC number, earlier it was
original jury. All right.
that is,
So that the court refers to that decision. So how can you defy this during the relevant time? Paragraph 1.
Do you dispute the fact that within 2 years she has not applied for course?
Yes, we have sent.
What she said?
We have sent for training, not, he did not avail. As an in-service, that was the specific stand in
She
the.
did not avail, she did not obtain B.Ed degree, that is an admitted position.
Yes, my lord.
But what about this? Please see Roman 1, paragraph 5.
My lord, I will come with that judgment, the subsequent judgment to this.
Tomorrow.
And also that standard stepping pattern.
And no question of
the stepping pattern regarding that prescription of the qualification for the post. So that your lordship can go through that subsequent judgment and this judgment.
All right, so is the judgment.
Yes, ma'am.
Let us see, you don't have that judgment?
Nabin Vohra versus State of Odisha. State of Odisha versus Nabin Vohra.
Give her that.
Yes, ma'am.
Learned counsel for the petitioner and learned AGA for the estate. The petitioner has relied on a decision of this court rendered in OJC number 1012 of 1996, relying upon which a division bench of this court had decided the matter in case of Vivekanand Das versus State of Odisha, reported in 2002, Volume 1, OLR 243. Stop. In response to the said submission advanced on behalf of the petitioner, Learned State Counsel has submitted that in a subsequent decision, this court's decision in case of Vivekanand Das bracketed Supra, in subsequent decision in case of
State versus Navin Kumar Beura, 2000
versus Navin Kumar Beura,
2011 1 OLR 169.
Reported in 2011 volume
1, my lord.
OLR
169.
169. The decision in case of Vivekanand Das has been distinguished. Stop. He submits that the decision rendered in case of Vivekanand Das does not apply in the facts and circumstances of the case. Stop. List this matter tomorrow so as to enable learned counsel for the parties to address the court on the point of the distinguishing features between the case of Vivekanand Das and
Navin Kumar Beura.
Navin Kumar Beura. Yes.
Obliged, Your Lordship.
Do you have the citation? You have taken citation?
Yes, Your
Have you noted that?
Yes, Your Lordship.
Item 23.
Your Lordship, on behalf of Senior Counsel Mr. J.R. Dora, Your Lordship. On behalf of Senior Counsel Mr. J.R. Dora, Your Lordship, in this present case, Your Lordship, the petitioner is challenging.
So you are arguing on behalf of senior counsel?
Your Lordship, on behalf of.
No, it generally happens otherwise. Senior counsel normally appear on behalf of the advocates on the court. All right.
Your Lordship.
Yes.
In this matter, Your Lordship, the petitioner is challenging the order passed by the tribunal, State Administrative Tribunal at Annexure 6, relevant page 20.
Arbitration Tribunal.
Your Lordship.
The order has been passed by the Arbitration Tribunal.
Administrative Tribunal, sir.
Administrative Tribunal. Yes.
State Administrative.
At page 25.
State Administrative.
At page 25, Your Lordship, relevant page.
Page 25.
Annexure 6. Page 25 is the relevant page, Your Lordship. Here, Your Lordship, the OA was filed, that is 805/2009, challenging the order of reversion at Annexure 5, by which the petitioner was rebutted to the junior most level of the post and thereby relieved. Even though the order of reversion, that is at page 18, Your Lordship, Annexure 5, page 18, it states that the petitioner was reverted, but they have mentioned. May I read, Your Lordship?
So what is your name? Kanungo?
Lakshmikant Tripathi, Your Lordship.
Lakshmikant Tripathi.
Your Lordship. The petitioner's name is, Your Lordship, Jamini Mohan Mahanti, Your Lordship. See that page 17, serial number 4.
Yes. So what is wrong in that?
Your Lordship. May I read page 18, Your Lordship?
18.
Yes, Your Lordship.
What is that?
In the result, Sri J. Mahanti, Section Officer, is reverted to the post of junior assistant in the tribunal for issue of final gradation list by order dated so and so, and he was appointed under other than OMS rule, which was in force with effect from 1976. Besides, there is no other sanctioned post of junior assistant in the tribunal, while one post of junior assistant is manned by a candidate who was recruited under OMS rule. In the circumstances, Sri J. Mahanti is relieved from his duties from the tribunal with immediate effect due to his reversion. Your Lordship, even though the order states reversion, because the post, there was only one post of junior assistant, that was banned by someone recruited through OMS rule, petitioner remained out of job from the impugned order 2000, that is 24th 2009, till his retirement, that is
2000?
24 March 2009.
24 March 2009.
Yes, till his date of superannuation, that is 30/3/2013.
Yes.
Your Lordship. Also, Your Lordship. Now, kindly, Your Lordship, come to the impugned order, that is on page 25.
Yes.
The petitioner was
You are challenging what? You are challenging your
challenging the administrative tribunal's order.
What was your grievance before the tribunal?
Your Lordship. I had worked for 29 years, Your Lordship. After working for 29 years and after being regularized and after 23 years of regularization, my order of regularization was challenged and my seniority was also challenged. And I was reverted back to the junior most position.
Your seniority was challenged in the light of this water resource department order number 9651.
Yes, Your Lordship.
And we do not find any irregularity in that policy decision. That a candidate appointed through any mode other than the mode prescribed in the recruitment rules in force cannot march over the candidate appointed through the mode prescribed in the relevant recruitment rules.
Your Lordship.
So you were put at the bottom.
Your Lordship, what has happened is petitioner was regularized by relaxing the OMS rule, Your Lordship.
No, it cannot be done.
Your Lordship, that is what happened in the case.
No.
The Supreme Court's judgment, what the learned tribunal has, the Supreme Court judgment, what the learned tribunal has given in respect of, that judgment is in my written note of argument, Your Lordship.
Mr. Counsel, the Supreme Court judgment is against you.
Your Lordship, that is what the learned tribunal has observed. But if we kindly see the para 11 of the Supreme Court judgment, there the Supreme Court has upheld the regulation, Your Lordship.
Your regularization.
No, regulation in pursuant to relaxation of OMS.
No. There is a, you can see recent Supreme, not recent, in case of Indian Forest Service officers, the Supreme Court says that the persons who were somehow or the other regularized, they cannot be given the seniority.
Your Lordship, even if that situation arises, then your lordship, in pursuant to that order, the petitioner remained out of job because he could not be placed subsequently. And that order,
Therefore, we are trying to understand from you, what was the relief which you sought before the tribunal?
Your lordship, I sought for that, it was deemed to be considered that I'm continuing in the post of senior officer, section officer, and given salary with regard to the section officer. Or in the alternative, if I'm to be continued in the post of junior assistant, I may be continued till my superannuation. And that was also the order of the learned tribunal. Learned tribunal passed. Your lordship, I prepared a date chart as regards to the status of the petitioner after the impugned order till his superannuation.
After the impugned order, you are challenging that order.
Your lordship.
So you are accepting part of that order and challenging part of that the tribunal order.
Your lordship. If your lordship is to found that he is to be reverted, then also he has to be paid duty pay from the period.
File a contempt petition.
Your lordship.
Sir, there are two parts. One, so far as your seniority aspect is concerned, you also say that if I was not to be given seniority, then I should have been posted somewhere and paid salary.
Your lordship.
In that regard, the tribunal has passed the order.
Your lordship.
You are not challenging that part of the order. Then what can be done? You are challenging the order of the tribunal in the present proceeding.
Your lordship. We are challenging that we should be deemed to be continuing as section officer only because we were relaxed. Our services were relaxed and we were regularized. And that order of regulation was challenged after 23 years. And it is a settled position of law that once a settled position of seniority, after years of lapse of delay, should not be unsettled, your lordship. On that ground, we are challenging that we should have been.
You are mistaken. Then you are mistaken.
Further, your lordship, during the course of the tribunal passed an order that is an annexure 8 to my rejoinder, your lordship, interim order, to stay the working of that order at impugned order annexure 5. Pursuant to that, the petitioner submitted his joining report. That joining report was rejected. After that, after some years, petitioner again approached in a mispetition so that he could continue at least in the post of junior assistant, as they have rightly said in the reversion order. That in that connection, the learned tribunal at annexure 11, turning page 49 to the rejoinder, said that you directed the arbitration tribunal, as he was working under the arbitration tribunal to accept his joining report and let him work as at least junior assistant till final disposal of the case. Lordship, in pursuant to that order, that is 23/2/2012, after 1 year, they asked the petitioner to submit his joining report. By that time, only 1 or 2 months was left for petitioner's superannuation. Then also petitioner submitted his joining report, but that was not accepted and petitioner in the meanwhile retired. Now the petitioner is only praised for pensionary benefit, as he is not getting any pensionary benefit. In pursuant to miscase before this honorable court, that is miscase number 15537/2014, and by order dated 19/7/2016, pursuant to that order, the petitioner is getting provisional pension. Now, petitioner is already retired. What we are claiming, your lordship, is only pension to be paid to the petitioner.
That you should have.
And duty pay from 2009 till 30.
Yes.
Yes, my lord, he is entitled to pension to that effect. There is no bar for it.
And your lordship,
So why is he not getting?
Provisional pension he is getting
Why not final?
because of this pendency of this case.
Forget pendency.
Yes, your
We will
lordship.
give you liberty, we will keep the
Yes.
matter pending.
Yes, my
We
lord.
will give you liberty, we will keep the matter pending, and
Yes, my lord.
you come out, we will pass that.
Yes, my lord. Your lordship may grant us 2 months time. In the meantime, we will regularize his pension.
Not 2 months.
My lord, because many documents, his period of service is to be regular. Your lordship, 1 month.
1 month. All right.
Yes.
What I lordship, I humbly pray your lordship, in pursuant to that order, from that order till the pendency of the petition between in the administrative tribunal, petitioner remained out of job from 23/3/2009 till his date of superannuation. That period has to be calculated as duty pay, your lordship, as he was not subsequently appointed because of mistake of the appointing authorities. They have reverted him, and there was no post. He remained vacant. He always used to go to the office, but due to not having any vacancy, he could not join. That the petitioner is innocent in that regard, Your Lordship. If his appointment was irregular, it is not the petitioner's fault.
Odisha Ministerial Services bracketed method of recruitment to the post of lower division assistant in the offices of head of departments bracket close rules 1975. Was this rule was framed for what?
Your Lordship, this rule was for recruitment to the post of lower division assistant in the office of heads of department. When the petitioner was initially appointed, there was no heads of department, Your Lordship. The arbitration tribunal was not the head of department. Later on, it became the head of department. That's why we are submitting that this rule does not apply to us.
Department. Under one PC Kanungo was appointed as lower division assistant in the office of the arbitration tribunal also. The petitioner was also appointed in the arbitration tribunal, but not in accordance with the OMS rules. उसको OMS rules का Odisha में stop. It appears that PC Kanungo had made a representation claiming seniority over the petitioner with reference to an order dated 17/3/2000.
Lordship.
17/3/2000 or 2008. What is this?
That was the year of Your Lordship. That is the gradation list, Your Lordship.
What is this order which has been quoted? Please come to page annexure 5.
Yes, Your Lordship.
Second paragraph. Water Resources Department in the order dated so and so. What is written there? 17/3 what?
17/3/2009, Your Lordship.
I don't know. What is that?
Annexure, that is 17/3/2009 is the annexure 4.
17/3/2009, which contained as follows: (as) quote, a candidate appointed through any mode other than the mode prescribed in the recruitment rules in force cannot march over the candidate appointed through the mode as prescribed in the relevant recruitment rules. Stop. Considering the representation of PC Kanungo and taking into account the said order dated 17/3/2009, the Office of the Arbitration Tribunal, Odisha, prepared gradation list wherein the petitioner was placed at serial number 4. So stop. The order further indicates that there was only one sanctioned post of junior assistant in the tribunal, which was manned by a candidate recruited under Odisha Ministerial Services, OMS, Rules 1975, the petitioner holding the post of section officer was required to be reverted to the post of junior assistant in the tribunal. So stop. Further, as there was no sanctioned post of junior assistant in the tribunal, while the petitioner was relieved from his duties from the tribunal with immediate effect due to his reversal. So stop. What is your parent department?
Your Lordship.
What was your parent department?
Water Resource Department, Your Lordship. It was actually Irrigation and Power Department. Now it has merged with Water Department, Water Resource Department.
The petitioner was accordingly relieved and he was to be given posting in Water Resource Department or Irrigation / Irrigation Department. So stop. Next.
Your Lordship,
It is the
either under the Water Resource Department or otherwise in the Arbitration Tribunal.
no arbitration, they relieved because there was no post.
Your Lordship.
They relieved you.
No, subsequently the tribunal has passed order. In case of vacancy of in any of them, he has to be adjusted.
That is different. Next. The petitioner questioned the said order before the tribunal. The petitioner's application has been dismissed by an order passed by the State Administrative Tribunal, which is under challenge in the present writ application. So stop. Next. After some argument, learned counsel appearing on behalf of the petitioner has confined his submission to the petitioner's claim of full salary from the date when he was relieved from the tribunal till he attained the age of superannuation on 30/3/2013. And post-retirement benefits. First off, it has been argued on behalf of the petitioner that the petitioner after having been relieved from the tribunal was given posting 1 month before the due date of his retirement.
He was asked to submit a joining report, never given posting, Your Lordship. He was asked to
Why
submit his
didn't you
joining.
join? Once you were relieved, why didn't you join?
Lordship, we have submitted joining report time and again. They have rejected.
No. First time when you were relieved in
Your Lordship.
2024/3/2009, when did you join?
He did not
He
join.
did not join anymore. Your Lordship.
Then
Lordship, they asked to submit joining report. We submitted joining report. Subsequently, we
did you join on 25/5/3/2009?
No.
No, Your Lordship.
Then
Lordship, as there was no post, that's why we could not join, Your Lordship.
you were required to go back to your parent department.
Your Lordship, in the parent department also there was no post, Your Lordship. Only one vacant
That
post.
is
was-
very difficult. That is a different question altogether.
As there was no post, we have submitted joining report. They have rejected it.
And post-retirement benefits. Top. Next. In such view of the matter is the case is adjourned to 4 weeks. So stop. We find no reason why the petitioner should be denied the benefit of denied post-retirement benefits. It has been stated on behalf of the state that provisional pension has been sanctioned. Stop. List this on the next date. The state shall be required to inform this court as to whether there is reason to deny the petitioner the salary for the period 24/3/2009 to 30/3/2013. Stop. In any case, comma, the state must take a decision in the meanwhile for payment of final pension and other retirement benefits
May I submit?
in accordance with
May I let him submit all the pension papers
Law.
so that unless he submits.
So stop. The petitioner shall be at liberty to submit his pension papers before the competent authority within 1 week from today.
Thereafter 4 weeks we will be granted. Thereafter 4 weeks.
Let it come, we will grant you further time.
Yes, ma'am.
Next. We are conscious of the fact that the petitioner in the present writ application is assailing an order passed by the tribunal, Orissa Administrative Tribunal. Under Article Orissa Administrative Tribunal. Stop. However, we are making an attempt to get the issue resolved by passing the order of the present nature for the reason that the matter has remained pending before this court for nearly 10 years. So stop. In such circumstance, it would be in the court's opinion, unjust to relegate the petitioner to any other forum to claim his post-retirement benefits and other leaves. So stop. All right.
Oblige, Your Lordship.
Item number 24.
May I please, Your Lordship? I am appearing on behalf of Mr. S.B. Jana. Your Lordship, on the last occasion, Your Lordship query was how the petitioner is aggrieved by the by the award of the Law and Labor Court by awarding 2 lakh rupees. Your Lordship, Your Lordship, kindly have a glance to the Annexure 3, the award passed by the Law and Labor Court. Operative part is paragraph 80.
You are the management.
I am the workman.
Or the workman.
Petitioner. May I permit you to place, Your Lordship? The first party management having suppressed material documents to rebut the claim of the second party workman, this court on the basis of the evidence adduced by the second party workman, both oral and documentary, comes to a conclusion that the second party workman had rendered continuous service under the first party management from 10/6/96 till 7/12/2010. And in view of admitted non-compliance of the provision of Section 25F of the Industrial Dispute Act 1947 by the first party management, the refusal of employment of the workman with effect from 7/12/2010, which amounts to retrenchment, is neither legal nor justified. Your Lordship, the petitioner challenging this award passed by the Law and Labor Court by claiming reinstatement with back wages. Your Lordship, as per the Section 25F, the management has not followed the Section 25F, and as per the decision of the Honorable Apex Court, when non-compliance of the section 25F, that amounts to automatically reinstatement with back wages. Lordship, kindly have a glance to the decision. Paragraph 6.
Can you be reinstated now?
Your Lordship, then the compensation must be adequate in nature, Your Lordship. But that 2 lakh rupees, it is very negligible, Your Lordship. And Your Lordship.
Whether you received the amount or not.
No, Your Lordship. The petitioner challenged this award and not inclined to receive such amount. And Your Lordship, even if the compensation, it comes to the compensation, there is also decision of the Honorable Supreme Court.
Forget decision. Decisions will not help you.
Yes, Your Lord.
Because of these decisions, he has not been able to even receive that 2 lakhs. And he must have spent 2 lakhs by now in litigation.
Your Lordship, kindly have a glance to the.
Yes, who is for the management?
Para 6.
Well,
yes, how much will you pay?
Well, as per the order of this London Labour Court, my lord, we had already in 2015, my lord, the decision was in 2014 also, and we had paid 2 lakhs check in 2015. But the workmen prefer not to encash the said check.
All right, now you can pay.
We have already paid that. We have
The 2 lakh that has not been received by him.
No, my lord, we have already paid them. They have not encashed it.
Oh, they have not encashed it.
Well,
So the amount is still, the amount has remained with you for last 10 years.
well,
Do something, you are management, you are a rich person. Pay something more.
my lord, in fact, at that time also, though we are not agreeable to the London Labour Court's amount, but we prefer not to file anything.
Mr. Counsel, anyhow,
My lord.
you could have paid 2 lakhs in 2014.
I understand, my lord. We are ready.
Now we are in 2024. So if double the amount you pay, we can dispose of.
Double will
Yes.
be 2 hours. But
Double is not less. Otherwise, if you want, we will decide.
No.
It is up to you.
No, my lord, I leave it to my lords. My lord.
No, don't leave it to my lords. You seek instructions.
My
You
lord.
seek instructions. This is what we intend to do.
No, my lord.
Either you agree to pay double the amount, or we will be deciding the matter on merits.
In that case.
As you wish. All right.
Yes, sir.
Yes, sir.
Oblige, Your Lordship.
As requested on behalf of the opposite parties, opposite party number 1, list this matter on 1 week. That is the only thing.
Some, if any amount may be indicated, my lord, that will be helpful because the company, I have actually, in fact.
All right. By the petitioner, who is a workman, has challenged an award passed in July 2024 by the presiding
2014, Your
officer.
Lordship. 2014.
14.
Oh, 14.
4th July 2014.
4 July 2014, passed by the presiding officer, Labour Court, Bhubaneswar, whereby, after having held the petitioner's termination illegal, without directing his reinstatement, passed an order for reinstatement and payment of back wages, directed for payment of a sum of rupees 2 lakh by way of compensation. Stop. Next. This writ petition has remained pending in this court for nearly 9.5 years. Stop. The petitioner has not received the amount of compensation so far. Stop. It is not in dispute that the employer, that the management intended to pay the amount of compensation to the petitioner. Stop. Next. Since the matter has remained pending since 2013, instead of going into the legality of the impugned order, learned counsel appearing on behalf of the petitioner has taken a fair stand that if the amount of compensation is reasonably enhanced, he shall not press this application or press this writ application. Stop. Next. List this matter on 4 weeks. Stop. We are of the view that interest of justice shall be subserved if the opposite party number 1 agrees to pay to the petitioner double the amount which was directed to be paid by way of compensation by the labor court. Stop. We, however, indicate that the court is not compelling the management to pay, to agree to pay the said amount. Stop. They are at liberty to contest the present writ application on merit. Stop. The nature of order which we shall be passing in the present proceeding shall mainly depend upon the respective stands which the parties take on the next date of hearing.
No presumption.
Now it's clear for you?
In fact, I've got the instruction to up to 1 lakh more, I may be, but I will take your call. They'll, and I hope they will agree to that.
Item 25.
Please, Your Lordship. I pray this honorable court to dispose this writ application as per direction dated 9/8/2020 passed in WPC number 20526 of 14.
We don't know anything.
This is a similar matter. The issue is all these writ petitions which are disposed of, the issue is the same. And the
Give the order, please. My memory is short. I don't remember things. So what is that order? What was there?
All the petitioners are pump driver.
Please give a copy of that order.
I have already, it is 6/8/2000, 6/8/2002. 2003.
You should have furnished that.
Is he correct?
Yes, it's covered by that.
Covered.
From minimum wages to the.
Yes, yes.
Minimum wages.
Like
Yes. The amendment petition I have filed to a petitions for including the in the meantime, the Sarpanch has been changed. The GP has been changed. So I have filed order 1 rule 10 petitions to include the opposite party in place of GP number Chandipur GP. This is my
Sarpanch is a post.
Sarpanch
which continues.
Yes, but the Sarpanch change of the area I am discharging my duty at Mirzapur village as pump driver. But my village, at the time of filing of the writ petition, my village under the Srikona GP. Now it is come under the Chandipur GP.
Which GP?
GP, earlier to the petitions, it was Srikona GP, but in Srikona, Srikona GP. But now it is my village come under the Chandipuri GP.
Chandipuri.
GP. So I have implemented opposite part number 6 as implemented opposite part number 6.
IA number?
IA number
1745 of 2023.
My lord.
It is stated by the London Council appearing on behalf of the petitioner that consequent upon delimitation, the petitioner's village now falls in Chandipur Gram Panchayat,
My lord.
which was earlier under Srikona Gram Panchayat. So this application has accordingly been filed for addition of Gram Panchayat, Sarpanch, Gram Panchayat, Chandipur, in the district of Baleswar, and opposite party number?
Opposite party number 6.
7 or 1?
Opposite party number 7. We have added, instead of substitution, we have added. All right.
Consultative procedural file.
Yes. Allow his ceramic.
Obliged.
Already you have filed consolidated.
Consultative procedural, I have already filed.
By substituting.
No, not by substituting, by adding.
By adding.
To be because title has been filed from your direction and respond number 7. Direction will go to respond number 7. Opposite party number 7.
6, my lord, 6. This is the Sarpanch of the 6.
Oh, now Chandipur you have made
Chandipur.
6.
And I am discharging my duty in the Chandipur GP.
So now respond number 7.
Now respond number 6. In place of Srikona GP, it has been included.
Addition hella, seta 7 hella.
7, my lord, 7.
No. Addition, he has made something wrong. He has made the opposite party number 6, Sarpanch Chandipur Gram Panchayat, and opposite party number 7 is Panchayat Extension Officer Chandipur. He has not made Srikona now. He has
Srikona is earlier.
Earlier, he has completely substituted by 2 additional parties, saying that Sarpanch is Sarpanch of Chandipur and Panchayat Extension of Panchayat Extension Officer Chandipur Gram Panchayat. Both you have.
Both
in place of Srikona
GP.
The said background, the London Council for the petitioner has placed before us a fresh cause title in the light of the aforesaid changes which has been taken on record. Sir?
Item 26.
Conducting counsel and Mr. N. Sarkar is today is ill. Let it come next week at any time.
As requested on behalf of the petitioner, list this matter on 2 weeks.
Item 27.
Lordship, may kindly have a glance to the last order.
Yes.
My lord, I have not come with an affidavit, but I have come with that order, my lord, he has been reinstated.
You have been reinstated.
When?
Yesterday.
No, yesterday, perhaps today.
Yesterday, that is the order to yesterday's order.
You serve a copy?
I am serving 3 copies are with me. I have served 2 copies. I
will take
ଦେଇଦେବି ଗୋଟେ copy ଥରେ ଦେଇଦେଲେ ମୋ ପାଖରେ ଧନ୍ୟବାଦ.
So it has become infectious now?
No, but it has not.
No, no, it has not- it is
It has not become in because so
My
far
lord,
as
here, I have
am
challenged,
coming.
I am the appellant, my lord.
Yes, I don't dispute that. Only that part of the arrear salary, your lordship may fix to end the other date so that it can be.
I am
paid.
the appellant, my lord, I am the
Because
headmaster.
my lord's order was that first you have to reinstate. We have reinstated it.
Yes, please.
I will take the instruction about the reinstatement. Let the matter be taken up next week or.
No, he has been reinstated, that is the office order.
Yes, my lord, let
So
it
what
be taken up
instruction?
1 week after.
What instruction on this? Let us see what is the issue involved. Yes, your fault.
My lord, for appellant. My your lordship can come to the impugned order passed by the honorable single judge. At page 37. Well, second paragraph. Considering the submissions of learned counsel for the petitioner, finding the submissions has strength based on the opening of service book, and further as this court finds the termination or disengagement order has been issued even without initiation of any proceeding involving the petitioner or assigning any reason for discontinuance of the petitioner. The impugned order is not sustainable in the eye of law. Law is also fairly settled that no regular employee can be issued with a marching order without putting him at least with a show cause. As a consequence, this court interfering with the impugned order by the Annexure 8 sets aside the same and direct the school authority opposite 4 to reinstate the petitioner to the post as he was holding at the time of termination forthwith. But however, considering that petitioner has not worked all through and this court interferes in the discontinuance of order after 18 years, this court directs the school authority to release at least 75% of back wages. And
You are managing committee.
I am the headmaster cum secretary of the school.
Of the school.
Yes, managing committee represented by headmaster secretary. Now they have the direction was to the school authority, means the managing committee to pay the 75% of his back wages, my lord. He was that he was an approved staff earlier, and he was getting the salary from the government, my lord, in shape of granting aid, my lord. Only the educational authority, my lord, DO, is liable to pay this amount, 75% to the respondent number 7, my lord. The school authority is not liable to pay, my lord. Therefore, I have challenged this portion of the order, my lord. This is an aided educational institution since 1694, and his service, respondent 5 service was approved earlier. He was getting salary from the government, my lord, in shape of granting aid, my lord, along with the other members of staff, my lord. That aided school has no source of income. Aided school was not paying the salary of the respondent of 7, my lord, respondent of 5, my lord. Now, this 75% of salary shall be paid by the educational authority, my lord, by the government of Odisha, not by the school authority. Their school authority has no source of income, my lord. There is no, statutorily, there is no source of income. As he is an employee of an aided educational institution, he is entitled to get the salary from the government. That is my submission.
And what is the order?
Order was that school authority shall pay, my lord, at page 37. All that the petition has not worked all through, and this court interferes in the discontinuance order after 18 years. This court directs the school authority, means the managing committee, to release at least 75% of its back wages.
You are opposite party number 4.
No, I am the appellant.
No,
there I am opposite number 4, my lord.
So why didn't you appear in that case?
Pardon?
Why didn't you appear in the writ proceeding?
Writ proceeding, my lord, That headmaster, there was no managing vested with the district education officer, my
No,
lord.
whosoever there was some managing committee, opposite party.
Only
number
that
four was
it
noticed.
is through, they should be repented by the.
Huh?
They should be repented by the DO, the government advocate, my
We
lord.
don't know. The managing committee is one managing committee.
Managed committee term expired and it is vested with the district education
So
officer.
The power was vested with DO. He did not appear.
The DO appeared, my lord, through at that time in
No,
inspector school.
this is the order. In spite of notice, there is no counter affidavit filed by the state opposite parties as well by contesting opposite party number 4 as yet.
Or my lord, that I was not permitted that time to file that.
There was the question of you.
I am the, my lord, he has implemented me as headmaster Anchalik High School. Ke ho gaya. As headmaster, I have no role to play, my lord.
Master, you should impose cost in such matters.
Therefore, that only that school authority, school authorities are not entitled. There is no source of income.
School authority, the respondent number 4 is the school authority.
No, he is not headmaster. Respondent 4 is the headmaster. Headmaster, how can headmaster will pay, my lord? Headmaster is, my lord, not the authority, my lord. Managing committee is the authority.
What is the salary of the headmaster?
Headmaster salary is, my lord, that scale of pay, I have no knowledge at present. Only he gets from
that much we understand. That the headmaster cannot pay from his own pocket.
One pocket, my lord.
The governing body has to pay.
Pay, my lord. Governing body, no, government.
Whosoever.
Government.
Managing committee or whatever.
Government is to pay.
The headmaster cannot pay from his own pocket.
One pocket.
So respondent number 4 was the body. He was
No, respondent 4 was not the body, my lord. Respondent 4 was the headmaster Anchalik High School, my lord. I was not the body. With the due permission, the managing committee filed this document.
You mean to say that in the writ petition, managing committee was
not made party.
Made party.
Made party.
But the direction was to the managing committee.
No, to the headmaster, my
To the headmaster was a party.
Headmaster was a party. Headmaster has no authority at all.
So he should have filed a counter saying that he is not the proper party.
Regarding that area salary, my lord, reinstatement, my lord, that DO has terminated the service, my lord, therefore that cause of action arose against the DO.
No, again, let us see who was the opposite party.
You will also kind come to page 13, my lord, of the appeal memo. Do you also get my lord, page 13, my lord?
Mr. Counsel, can we understand from you
Yes, my lord.
who was required to be made a party in the writ proceeding?
The managing
Or
committee.
who was the necessary party to be impeded
The managing
for the
committee.
relief which has been granted?
Well, the managing committee is the necessary party.
Managing committee.
Yes.
So who was the managing committee then?
Then, my lord, at that time, that managing committee was
That power was vested in DEO.
DO. That inspector of schools.
Whosoever.
Yes.
Who was respondent number 4 in the writ proceeding?
Headmaster of the school.
Headmaster of the school.
Yes.
So why no counter affidavit was filed?
There is no cause of action against the headmaster. Headmaster has now terminated the service.
But
my lord.
notice was issued. In fact, it was,
Notice,
it may
yes,
be
yes.
an act of foolishness on the part of the institution or institution of the High Court, but you should have responded.
Yes, my lord. He should have. He should have responded.
No cause of action, you decide.
No. But I can decide. my
What is this?
Only that he is an approved staff there.
Oh, no, it's a fit case for imposition of exemplary cost. Vesting court's time. The fellow is fighting for more than 24 years.
No, I am not responsible, my lord, for years. I was not his authority to terminate his service, my lord.
You are responsible for filing this appeal.
No, appeal was filed by the managing committee, my lord. With the permission of the Honorable Court, my lord. Managing committee is the appellant.
Nico?
He is entitled to this much of salary, 75% from the government. my lord.
Who will pay?
Management is to pay.
Management, no, he's an approved staff. It is an aided school since 1694, my lord. He was getting the salary from the government.
Why management is to pay, my lord? There is no post of 4th year.
No, that is not.
Management appointed him. So wrongly his post was approved, and when it came to the notice of the government that post has been approved, government directed to discontinue those posts. On the basis of that direction, his case he has been terminated.
Well, that is not correct proposition. My proposition I am placing
Page-
before.
page-
Let
page-
me
You
resolve it, both of you. Let me place my proposition.
Just a minute, just a minute.
What
Just
happened?
a minute. Let, before this court, an office order has been placed, issued by the district education officer, Kalahandi, from which it transpires that respondent number 5, who was the writ petitioner, has been directed to be reinstated in service. First off, the said order has been passed on 28/2/2024 in the light of the order passed by one single judge in the writ proceeding, which is under challenge in the present intra-court appeal. Top, the managing committee
Yes, ma'am.
of the school, which school?
Well, the Ancholika High School. Ancholika High School, Kegaon, at post Kegaon in the district of Kalahandi.
And the district education officer and learned counsel for the state are state have raised disputes as to whether the governing body or the state shall pay to the petitioner salary for the period during which he remained out of service in the light of this court's order, in the light of the order passed by the learned single judge dated 6/2/2018. Full stop. Next, in the facts and circumstances of the case, we direct who is the head of the department? No, who is
Director secondary.
the director secondary education to take a decision in this regard and inform this. in this
File an
regard
affidavit,
after
Your
giving
Lordship.
the managing committee an opportunity of hearing and inform this court within 3 weeks from today. Let this case on 3 weeks.
Okay.
Item number 28.
You want to pass over? Pass over.
Also, 1 week.
Item 29.
20, two more. A state appeal is seeking password. Your Lordship, may call this.
Yes, who is there?
20, I am the appellant. So your Lordship, may fix it to next week for 5 password.
Next week.
Next week.
Next week.
29.
In 29, 2 cases are there. The basing on which the order has been passed, that has been stayed before the Honorable Apex Court.
29.
My Lord.
Which order has been stayed?
That Alok Mishra case. That you'll also see that the order.
Answer 377.
Yes, ma'am. Page 77, you'll also. Page 76, annex 3, ma'am.
77.
76.
77.
You'll also see that this order has been passed, relying that order passed in Alok Mishra case. Alok Mishra versus State of Orissa, WPC number so and so. So, that order is under challenge before the Honorable Apex, and the Honorable Apex Court has stated that I have annexed that. You'll also see page 78 is the order of the Honorable Apex Court. So I pray that it may be deferred for some time after disposal of that case, both will come.
Yes.
That in Apex Court or Supreme Court, that date is fixed to 5th March.
Any date after
The-
disposal of that case.
An order dated 10/6/2020, passed in WPC number 8200 of 2020, is under challenge in the present intra-court appeal, which has been passed following Supreme Court's decision. Following
High Court's decision.
This court.
a division bench.
No, my last single judge. Alok
Based
Mishra.
on
In
decision of this court in case of which case?
Alok Mishra
versus
versus
state,
State Board.
WPC number
State of
16917.
Odisha. Stop. It has been stated at the bar that an SLP has been preferred before the Supreme Court against the decision rendered in case of Alok Misra Brahmapura, in which notices have been issued and the order passed in the said case has been stayed. So stop. List this matter on 8 weeks, awaiting outcome of the SLP pending before the Supreme Court.
7667 of 2020.
79, please.
Supreme Court in case of.
Page 79.
No, but why the matter straight away went to Supreme Court?
Since 2020, madam. 767 79767 of 2020.
Why no appeal was filed?
I have annexed that copy.
Directly how?
Yes, madam, because
Agency single-
because in division bench, same order was passed, in honorable single judge also passed same order. So
Oh, that other SLP,
Are there.
which is tagged to that.
yes, madam. That's
Oh.
the case.
Another SLP was there,
All
SLPC
right.
6214. Of 2020.
Yes.
Item number 30.
My lord, on the last occasion, I submitted to this honorable court that the learned AG will conduct this matter. But he's not well, my lord. So my lord may permit me because they are raising objection. So I will place my. Here, my lord, before I take my lords to the judgment, a policy decision of the government to merge more than 7,772 schools in accordance with a policy of the government of India was under challenge before this honorable court. Now, my lord, I am challenging the judgment mainly on 3 grounds. My first being, it's a policy decision and should not have been interfered with. Number 2 being, out of 7,772 schools, my lord, 4,800 schools have already been merged without any objection and they are running. That aspect was not appropriately taken care of, considered by this honorable court. Number 3, my lord, our policy itself very clearly says that we are adhering strictly to all the provisions of the RT Act and other relevant provisions of the Act. My lord, if for the sake of argument, that will be my third limb of argument before this honorable court, even for the sake of argument, if it was found that in some cases, those strict provisions of the rules or act was not adhered to, then my lord, in those specific cases, the honorable court should have interfered with. Instead of quashing the entire policy. Maybe, my lord, in some cases, in 1 or 2 or 3, 4 cases, there has been allegation that
there was deviation. But for that deviation, the entire policy could not have gone wrong. These are my three main grounds on which I have approached this honorable court. Now, may I take my lord to Annexure 1 as page 87. It's a long judgment, my lord, so I will have to place the relevant, so my lord may kindly. Annexure 1 and page 87, ma'am. My lord, Sabi?
Yes, please.
My lord, His Lordship see that this is a guideline for rationalization of small schools across states for better efficiency. My lord, this was the policy of the government of India floating. Now, my lord, finalizing guidelines for rationalization of small school across states for better efficiency regarding. My lord, I'll be only taking to the relevant portions, my lord. Then, if my lord will require me, I'll go into the details of it. Now, my lord, this was page 87, 90, 91, 92, 93, my lord, all the features we have, it has been narrated, my lord, and it is very clearly written that all the provisions of the RTA Act, Right to Education Act 2009, and other provisions and the modalities to be covered as to how every aspect is to be ensured, those things are there, my lord. Pursuant to this is Annexure 1, my lord. I am not taking, my lord, to details of all the features. Now, my lord, the next is the state resolution accepting that. My lord, we'll find that at Annexure 2 as page.
No, but what is the main dispute?
Dispute is, my lord, this honorable court has caused the very notification by which all these schools were merged.
Merged into what?
Because for rationalization, what we did, my lord, we found here shortfall of students, shortfall of infrastructure, teacher-student ratio. Within 1 kilometer radius, we found there are more than necessary number of schools. So we merged, we consolidated. For rationalization, we made it at least to give it a better education, better facility. Well, all details have been taken note of.
What merging is, see, if there are two things, then both of them can be merged. There are four things, all of them can be merged. Or if there are 5 schemes, all the schemes can be merged. What happened? What is the concept of merger in this case?
Suppose one school has 10 students, one school has 20 students. So we merged that to make it, we made it one school. So the teachers, everything we provided, and we made it one school.
All right. So by virtue of merger, you have closed certain schools.
Yes, ma'am. We have closed certain.
That is the consequence.
Yes, ma'am.
All right.
Infrastructure facilitation. Infrastructure facility.
My lord?
Infrastructure facilitated.
Yes, ma'am. We gave that extra facility, and because they got extra teachers.
With the leave of my friend, the short point before the single judge was whether you can have a policy contrary to the Right to Education Act and the rules framed thereunder. The central government has framed rules. The state government has.
That was the only question.
That was the question. The single judge found that their policy was contravening the act and the rules. And accordingly, the policy has been struck down. This is the long and short of the case. I have given a short note regarding this. So on that ground alone, the single judge has said that the policy cannot be.
All right. According to him, they have not violated any provision of the RT Act, nor any guideline issued or any rules issued framed under the.
My lords, let him show that because
this is,
yes.
All right. Yes.
So, my lord, the next is my lord.
Who are you?
My lord, who is he?
Interview number 752.
कितना नंबर है?
I don't
30.
This matter.
30 है तो आप बैठिए. अब आप ही का केस सुनवाई हो रही है.
I'll apprise my lords. Actually, there were several writ petitions disposed of.
We can understand.
The state has come up with one single appeal, only one writ appeal. So there are a lot of beneficiaries of this order of the Honorable Single Judge. So he might be one of them.
आप बैठिए वहीं पीछे.
खड़ा होने की जरूरत नहीं है.
नहीं, ये तो कोई भी नहीं. ये तो कोई भी नहीं.
So there were so many writ petitions.
Yes, ma'am.
And you challenged on the common order was passed.
My lord, this was taken as the lead case. So we have,
No, then you have accepted other orders. Passed in other cases.
In so many cases also interveners are there. Minors will also allowed.
yes, my lord. That's
It's a very difficult situation. You will have to prefer appeals, otherwise you accept other orders. Accept orders passed in other cases. You take instructions, otherwise it become very.
In fact, we have given a judgment of the Supreme Court squarely covering this issue. Unless they challenge those orders, on that ground alone.
Otherwise, this writ application, this appeal can be dismissed on that ground.
Yes.
yes, ma'am.
That
There's
you
a
have not
recent
assailed
order
other-
of the state only. State went to Supreme Court. Supreme Court recorded this and has said that on this ground alone we will
Yes.
dismiss the SL.
Yes.
Niranjan, state versus Niranjan.
Right. My lord, I will verify that part.
As requested on behalf of the appellant, place this matter on Monday.
My lord,
Seek instructions. We don't know whether the state may say that we withdraw the appeal because they have not filed appeals in other cases.
may I pray Thursday, my lord? Next
No,
Thursday.
this is 2021.
Next Thursday, my lord. It will be
All
next
right.
Thursday.
We cannot file appeals in other cases. Very difficult. Time barred, more than 1,000 days.
So our convenience note may be kindly kept on record.
Please, thank you.
We are all grateful.
Item number 31.
My lord, item number 31 is similar to that mallards that batch mallard heard day before yesterday, and mallards have posted it to 4-3. That matter.
Which matter?
That advertisement mallard wanted to see the original.
As requested on, list this matter on 4/3/2024 with
My lord, that number I will provide.
Do you have the number?
No, my lord, I don't have the number.
I will provide to court master. I will provide before my lord's rise.
Item 32.
This is a matter.
Yes, this is the matter in which you are making a mention.
Yes. This matter, in fact, was heard in extenso by your lordship's predecessor.
All right.
In fact, judgment was.
Could not.
Yeah.
I
will
pardon my notes.
They are appearing for appeal number 9 and 10. The second matter. And the next is Kalyan Fortnight, the other matter. One of them is the easy protocol. Lesson will be explained today. He will not present. Also keep it to any date.
Yes, my lord, we have only one prayer, my lord, because 179 posts have been stayed. So we pray.
We will see.
My lord.
As requested on behalf of respondent number 9.
Kalyan Fortnight.
Is this matter on? And 2 weeks.
2 weeks.
2 weeks.
Interim orders to continue.
Interim orders shall continue in.
My lord, 2 weeks.
2 weeks. Because of the demise in this time.
If you also fix up a date, we have no objection.
2 weeks, yes, it will come.
Fine.
And if, yes, interim order will continue. And if you want a particular time if the matter is urgent and if the matter requires final
Fix at 2 o'clock.
2 p.m. my lord.
2 p.m.
2 p.m. we don't know whether we are on that.
2 weeks after any date of 2 p.m.
2 p.m. after 2 weeks.
Yes.
All right.
Yes. Yes.
We make it clear that no adjournment shall be granted on the
Next
date.
And it will be like taken up at 2 o'clock.
Item number 33.
Your
Lordships, I prefer a passover.
requested on behalf of the petitioner 1 week.
Item 34.
Your Honor, if I fix a time for this case, because this is the case which has suffered numerous adjournments.
Which
And I am
one?
at the receiving end of the
33.
33.
So make a mention on the next date.
Today, he's just asked for a Passover.
Passover, so we have adjourned it for a week. So when the matter comes after a week, you just make a mention, we shall see to it that the
As
matter is heard.
As your Lordship.
All right, just remind us.
We'll do that. We'll do that. Problem.
Item number 34.
34, my lords, remember, this is work charge case where AG was to address, but he's not well, my lord. So may I pray, my lords?
When? When do you want?
My lord, may 10 days after, my lord.
I am for the respondent. 2 weeks as requested on behalf of the. You are appellant?
We are the appellant.
Behalf of the appellant.
Item 35.
37.
Yes.
Item number 35.
My lord, 35.
35, my lord, on behalf of Mr. Dasmal, kindly taken up tomorrow, my lord.
Tomorrow.
Tomorrow, my lord.
You are for the respondent.
Respondent.
As requested on behalf of the respondent, list this matter tomorrow.
Item 36.
36 matter of regulation, my learned friend has appeared in this case. Also may fix any date next week for hearing.
So no delay has not been found on 350 days delay.
Not 350 days, my lord. In fact, delay is 90 days. Delay is 90 days because filed on 8/9/2022. So I am covered till 1/6/2022. From 1/6/2022 to 8/9/2022. That is not hardly
90 days is nothing for the estate.
Not 90 days, my lord.
90 days delay is nothing for the state of Odisha.
Covered by 1/6/22?
Till 1/6/2022, I am covered by COVID.
No.
Till
Honorable
1/6.
Apex Court said
28 to
February by
90
February,
days, 90
whatever list was not filed or pending, you have to complete within 90 days.
90
So
days.
that ends in May 29 or 28.
No, my 28 to 2022. The cut-off date.
Further condemnation, how will you?
90 days. So
Honorable Apex Court has capped it.
It covered up to 1/6/2022.
Further 90 days you seek.
That 1/6/90.
How can you say that 90 days delay?
Thereafter 90 days. We are covered till 1/6/2022.
We will see.
So this has been filed on 8/9/2022.
We will see. We are not passing any order on limitation. Yes, next.
Item 37.
Only next week. Item
37.
My lord,
37 will come along with 34, my lord.
34.
So 34. That Norsu Pradhan case.
The portions are continuing for last 30 to 35 years. The court has the terms of the.
AG will argue this matter.
All right. Advocate General will argue this matter, he's saying.
It will come with 34, my lord. 30 item.
Similar, identical issues.
Yes.
regular.
This is a regular issue.
Let's this matter on
14th one.
Oh, nice.
Item 38.
All these cases relates to. May I please, my lord, sir? All the first petitioners. My lord, in this case.
0.4. Yes.
In this case, writ table number 1350 of 2022. Next, sub item, my lord. Writ table number 1350 of 2022.
Yes.
My lord, Mr. Swai appearing in this case. So I pray your lordship kindly taken up next week.
Who is appearing?
Mr. K.K. Swai, Kunal Kumar Swai.
As requested on behalf of the
I am ready
appellate.
for. I am also one of the applicants. I am also one of the applicants in all the cases.
50 of 2022. List these matters on 1 week.
It's a picture date because
39.
Date is already there.
Much obliged.
Yes, madam.
Madam.
Yes, please.
Item 39.
Item 39, madam. Item 39, 40, 41 are all identical in nature. Here, my lord is holding the brief WA 95.
We are not holding any brief.
My lord.
We don't.
My lord, paperless. This is, I am submitting from WA 95 of 23, my lord, the first case.
Just a minute. I got 39,
I was-
40 and 41.
I was submitting, my lord. I will prepare a short note because a judgment of the Honorable Division Bench is in my favor. Honorable Single Judge the judgment has gone against me. So I'll make a small note and so that I will place it for proper appreciation of my lords. 39, 40, 41.
My lord, this is petition for delay, continuation of delay by the appellants. And there is 523 days delay.
Yes, how do you explain?
No, my lord, this is 16/7/21. And we have
23.
95 of.
So there is a
95 of 23.
But apparently, my lord, the legal position goes in my favor, my lord, because the Honorable Division Bench has held in my favor. Because the Honorable Division Bench in a writ appeal only held that yes, power is available. I have also annexed that. My lord, may I kindly hear this?
On behalf of Mr. Dole. 40.
All right, we are
My lord.
respect.
Can it come
We are
one day?
required to rise
My lord,
for
may I
some
submit?
reason.
My
We will
lord.
hear you tomorrow. We will hear you tomorrow, madam.
My lord.
On the point of limitation also.
My lord.
You check up whether you will get that lead period.
Item 49, entry model is today.
We may be, my perception may be wrong. You just check.
Under item 42, there is a stay order, so I'll pay for it.
My lord.
42 will come tomorrow. Oh.
My-
All the leftover matters will be taken up tomorrow.
My lord.
Item 53, I
My
pray
lord.
for next week, my lord.
Let it come tomorrow. Tomorrow you can.
My lord.
Not for the entry model exchange wherever it is.
Including item 5 in Appendix 49.
My lord,
Because my-
tomorrow I will not be available. Tomorrow I have to another matters in revision bench, so also in the single bench.
Division bench, the High Court,
Yes, my lord.
then you can come.
It's item 45, my lords, my learned senior is there, let it come next week, means, I mean.
Well, day after.
Fresh admission list because it has not yet been admitted.
Big matter.
Fresh admission.
45.
45.
Any day next week.
45 as jointly requested. This matter on 1 week.
Right.
45,
Yes, ma'am.
My lord, day after.
40, you are in 41.
My lord, I am 39. Is that day
39,
after
40,
tomorrow?
41. 39, 40, 41 ko kar dena.
Can it come
1
on
week.
Monday?
We are adjourning it for all the occasions, all those matters for a week.
Day after tomorrow.
No, 1 week.
53 also for Monday.
In the fresh admission list.
What is your matter?
Item 49.
49, this matter next week.
Yes.
The interim order shall continue in the meanwhile.
Item 53 I pay for next week.
That will come tomorrow.
Your Lordship, in item number 47, I pray for 2 weeks time to file rejoinder.
47.
So, my lord, in item number 47,
2 weeks time for.
item number 47, this has come up because of my mention, my lord. Your lordship, recollect, my lord, I had filed a petition. I had made a mention. Your lordship said that file a vacation of petition and then make a mention, my lord.
He is seeking adjournment.
My lord, he took the time since, my lord, 2 months.
Not done. Tomorrow.
Tomorrow.
Your Lordship, interim order to continue.
Pardon, my
Interim order shall, tomorrow we'll see.
Tomorrow.
Pardon, my item 44, my lord. State has filed an additional affidavit. Explain short adjournment to.
We'll see tomorrow.